Okay.
May it please, Your Lordship. Your Lordship, I would like to take Your Lordship's indulgence in respect of this item number 6. In this case, Your Lordship, I am the counsel for the appellant, and it has come to our attention from the registry that some other advocates have filed a wakalatnama for the appellant. And I believe that there's an office note saying that no consent was taken from the previous counsel. And the problem is that I was never informed about this either from my client or from the the advocates who have recently submitted their wakalatnama. In fact, Your Lordship, I believe that the practice of this is in violation of the Guwahati High Court Conditions of Practice of Advocates Rules of 2010. Rule number 3 to be precise actually. And rule number 3, the first proviso, Your Lordship. The first proviso provides that, provided that where an advocate has already filed an appointment in any proceeding, it shall be sufficient for another advocate who is engaged to appear in the proceeding merely for the purpose of pleading to file a memorandum of appearance or to declare before the court that she
Client has engaged another senior counsel.
No. Advocate.
This is item 6.
No, not senior counsel, not the counsels whose names are reflected in the cause list. Some other counsel, Your Lordship.
In
They
item
have
6.
in
Item
i-
6.
In item 6. Office note is there, Your Lordship.
Okay, he has come to his knowledge that his client has engaged some other counsel, and that is beyond his knowledge. Stop. He submits that no consent has been taken from him by his client or by the newly appointed counsel to appear for the appellant. Stop. He therefore submits that he may be given a week's time to sort out the matter. And prayer is allowed. Matter stands adjourned for a week.
Deeply obliged.
For orders, item number 4. Item number 4.
You are the appointed Amicus curiae.
Yes, my lord.
Miss Valentina, learned counsel. Valentina Laldin Pui, learned counsel, submits that she has been appointed as the Amicus curiae to appear on behalf of the appellant. Stop. It is seen that the LCR has been duly received. Stop office to prepare the LCR expeditiously and thereafter list the matter for orders once a copy of the paper book is furnished to the learned counsels for the rival parties.
Obliged.
For admission, item number 1.
Yes.
My lord, my senior was to appear through virtual mode, but he's facing a slight difficulty in the internet connection. So, can the matter be passed over for the time being?
Passed over for the time being.
Item number 2.
What is your instructions?
Yes, my lord, we have received the instruction regarding the approval of the work estimate. We have already submitted the copy of the approval.
May 31st, 2025.
Yes, my lord.
Yes, Miss Valentina.
My lord, I have also received the copy of the order, my lord, letter.
Is this case similar to the one which we took
No,
up
my lord,
yesterday?
the other one was River Langkai, whereas this one is River Bairabim. Sorry, Teire, my lord.
They.
Yes, my lord.
But the contractor is the same.
Yes, my lord.
Yes, Miss Rosaline, what do you say?
Yes, Lordship. With the prolonged time, they have a little over 7 months now. Now that the date of completion is 31/5/2025, if this PIL can be kept in abeyance and be listed after 31/5/2025, Lordship. To see that the work is completed with the time frame, Lordship.
What do you say? Common advocate, you please file this instruction by way of an additional affidavit.
Yes, ma'am.
We'll adjourn this matter till March. And meantime, the contractor will file the status report
My lord.
by that next date. Completion time is May, so we'll list it before May in March.
Yes, Lordship.
Please write down. Parties are represented by the respective councils. Stop. In terms of the last court's order, comma, Ms. Van Naisiami, learned government advocate appearing for the state respondents, has produced the instructions that she has received, which is to the effect that the extension of time or the time for completion of the work has been approved with the completion date as 31/5/2025. As was communicated to the contractor by the Senior Executive Engineer, PWD, Kortha Division, Kortha, White Communication dated 16/8/2024. Next para. Having regard to the above development, we deem it proper that the matter be listed again. No, next year. Next year. In the last week of March, on a date to be fixed by the registry. March after that, you write 2025. Huh? Last week of March 2025, on a date to be fixed by the registry. Stop. The learned government advocate shall file an additional affidavit incorporating the instructions that she has received and produced before this court today, within a period of 2 weeks. Stop. The contractor, bracket respondent number 1, shall file a status report about the work that has been completed with supporting documents. We need a calendar actually. 2025. Anyway, we'll fix it up. On or before 20th of March. Just check out whether it's a Sunday or Saturday. If it's that, we'll 20th of March 2025.
Thursday, my lord.
It's a Thursday.
Yes, my lord.
25.
Yes, my lord. 24. It's a Tuesday, sorry.
That's perfect. 25. 20th of March 2025.
20th of March is
20th
Thursday,
20th
Lordship.
is Thursday, my lord.
20th is Thursday.
Yes, ma'am.
You said Tuesday.
I was looking at the 25th, my lord.
Okay. Then let's make it 18th. 18th of, on or before 18th of March 2025. Then what is the Wednesday on the last?
26th.
Let the matter be listed again on 26th of March 2025.
Obliged, Lordship.
Item number 3.
Not here, okay. Yes, Dr. Saraf, you are here finally.
I'm obliged to Lordship for giving me the opportunity for visiting the IGL for the first time.
First time.
First time.
That's a good thing. Parties are ready otherwise?
Yes, my lord.
Okay. Mahak, I think both of you can leave. Go and type out the order. You can go. Mr. Saraf, I think we'll have to recapitulate what we had heard, what you had submitted last time,
In short,
briefly,
my lord, because the my
for the
lordship-
benefit of us, for our benefit, and
My lord,
especially
because
my brother also, I think first
Yes,
time
yes,
for him.
My lord. My lord, in fact, if your lordship may take the compilation I've given for index.
Compilation. Okay, yes, compilation.
My logistic letter has got it, my lord. Has your lordship got it, my lord?
Yes, we have it.
My lord. Your lordship can see, my lord. Notification of the section 4 was issued on 14/3/2012, which
Yes.
you lordship find at page 2. Thereafter, notification of the section 6 was issued on 7/6/2013, which you will find lordship at page 3.
Three of this compilation.
Comparison.
Okay. Yes.
Now, thereafter, my lord, the draft award was prepared and sent for approval on 11/3/2014, which you will also find at page 6. Now, the total compensation payable was determined at rupees 7,63,28,707, which amount you will also find at page 9.
Yes.
Now, the draft award was returned by the government while letter dated 3/3/2015, which you'll also find at page 12. Then again, look, the draft award was resubmitted while letter dated 6/5/2015, which you'll also find at page 13.
Yes.
And the request was made for approval of the draft award, which you also find page 14. Now, by the press award, my lord, the compensation was determined as rupees 12,80,076,247, which you'll also find at page 15.
Yes.
Now, the approval was granted while letter dated 21/5/2015, which you'll also find page 16 below.
Yes. 16.
Page 16 you'll also mechanically see.
Yes.
My lord, in the last part, my lord, the amount in respect of so-and-so, of village so-and-so, amounting to rupees so-and-so, has been omitted for want of clarification as sought for. So out of the total award which was determined by the collector, my lord, this amount was not approved.
From which page are you
Page
saying that?
16, my lord,
16.
16, which is the approval letter, my lord.
Has been omitted. Okay.
My lord. And thereafter, my lord, says genuineness and authentication of the parties should be as per the registration record, register maintained. Proper marking of the land acquired should be done as per sport. Recalculated amount of the award after deducting rupees so and so of so and so is enclosed. So out of the total amount determined by the collector, my lord, this amount was not approved. And after deducting the said amount,
12, the amount calculated was 12 crores 80 lakhs,
My lord.
76,000 like that.
my lord,
And out of which 45 lakhs
my lord, 56,736
has not been approved.
not approved,
The remaining approved.
remaining approved.
Okay.
Now, the draft award was cancelled as no final award was made within 2 years of the notification under section 6, which you'll also find page 17.
Yes.
It says, my lord, in reference to the letter number so-and-so, I am directed to produce the observation of the Law and Judicial Department of so-and-so. The matter has been re-examined in the Law and Judicial Department and returned with an observation that the instant proceedings was started by issuance of notification under section 4.1 of the Land Acquisition Act 1894 and declaration under section 6 issued on so-and-so. Hence, the instant proceedings is not saved by notification number so-and-so. However, as 2 years have lapsed without an award being made under section 11 of the Land Acquisition Act, without the proceeding being stayed by the order of the court, the entire proceedings have therefore lapsed as per the provisions of section 11 of the Land Acquisition Act and so-and-so.
2 years' time has to be calculated from which date?
No, from the issuance of the notification under section 6,
6.
my lord.
Okay. So date was 7/6/2013,
My lord.
and but the approval came in 21/5/2015.
That is the issue, my lord. That the approval, I will place before your lordship the judgment of the apex court, which says that the award is approved as it is. Then it will treat it to have been awarded past. But if it is not approved as it is, then there is no award.
What is that judgment?
Now I am placing for us. I
Okay.
just give some
Okay.
facts more, my lord.
All right.
Now, this was challenged before this honorable court, my lord. Learned single judge passed the order at page 18.
What was the finding otherwise?
Below the finding was that the award was deemed to have been passed. You'll also kindly see at page 20,
Paragraph?
paragraph 9,
Yes.
the draft award number so-and-so clearly states that notification under section 4.1 of the act was issued on so-and-so. The declaration, the section 6 of the act was issued by the government of Mizoram Revenue Department on so-and-so. The draft award was again signed on so-and-so. The approval of the award was, state government was conveyed by the undersecretary to government of so-and-so. Thus, the declaration under section 6 have been made on 7/6/2013 and approval of the draft award having been made prior to the expiry of 2 years from the date of the declaration under section 6, the observation law and justice department that the entire proceedings are less than section 11 of the act does not seem to be correct.
So that is where the thing which I pointed out.
My lord, exactly the same view was taken by
You
the-
say that if it's approved in toto,
My
then award is passed. But
my
if it's only part,
My lord.
then there's no award.
Now, thereafter, the learned single judge directed that the payment should be made in terms of the award which was passed.
Okay.
Now,
And what about the remaining that which was deducted? Anything to that effect? Any?
no, my lord, thereafter the further things were there because in the award which was passed, there were many false claims, bogus claims. Now, somebody filed a writ petition before this honorable court that there are bogus claims, false claims are there in respect of
That
the,
was after this judgment.
after this judgment.
After this judgment.
After this
No, before that, regarding the award which was cleared, court said that you paid.
Pay.
And the remaining balance which was withheld, any direction?
No direction.
No direction
That the direction was that you amount whatever was award was there that you pay.
that you pay. So in the meantime, somebody had filed some writ petition
My lord.
saying that there are bogus claims.
Bogus claims are there, and this honorable court passed a order. You'll also find
Relating to draft award 3 only.
my lord,
Draft award 3 of 2014.
my lord, my lord. Now, you'll also kindly see my intellectual application number 1902. You know,
Where do we get that, IA?
IA number 1902.
In the writ appeal.
Writ appeal.
What is this about?
Well, that is the order passed in the by the writ petition, my lord. Subsequently, the writ petition was filed that there was bogus claims, and the
Yes.
on that the judgment was passed by the my lord, learned single judge of this Honorable Court. And you'll also kindly see the judgment at page 99.
No, why did you file this IA? To incorporate that?
My lord, the division bench, my lord, in the appellate court told us to bring the papers and documents all before the court. Because the scrutiny was made on the basis of direction issued by the learned single judge. And after that, my lord, it was found that the number of claims were bogus. 167 claims were bogus claims. And you'll also kindly see, my lord, page 99. To bring on record, my lord, the relevant findings of the scrutiny committee.
By which order? Let us see the order first.
My lord, the lordship will find the order at page 99
In the writ appeal.
in the IE, my lord.
No, IA is in the writ appeal.
In the writ appeal.
So any direction was given by the writ appellate court to file the IA?
My lord, there was a direction, my lord, that you bring on record the papers and documents.
By which order? IAs of the year 2018.
My lord. Direction আছে নিচে। My lord, you see 11/5/2018, my lord, in the writ appeal.
2018.
11/5/2018 in the writ appeal.
Okay, there are two order sheets. That order is not here. Do you have a copy of the order?
11/5/2018.
In my copy, the order starts from 9/11/2018.
My lord, I'm just checking, my lord.
Just a minute. What is the date you said?
11/5/2018, my lord.
11/5.
11/5, no? 11/5, my lord.
There's one more order, 31/5/2018.
Chapter 9.
And this is 19, sorry. 31/5. No, this copy is here already.
9. Online আছে? Look, I have not gone to the copy, but we are checking with the online, whether it is uploaded.
No, I don't think there was any such kind of permission
On
to file the IA.
It is in my noting.
It was filed by the appellant on their own. Purpose of filing this application was to stay the judgment in order
It is
and further proceedings of contempt case.
in my noting. It is mentioned the appellant directed to file interpretation narrating all the facts of the case along with the prayer for stay of the order and appeal.
That was the order.
It is mentioned, my lord, in my noting, my lord, that. is
In
what-
your noting. That is why I was just going through this application. Normally, if such kind of order is passed, in the cause title, it gets mentioned.
My lord,
An application in terms of the order dated so and so,
my lord.
for stay and for.
Absolutely correct, my
All
lord.
that.
Yes, you're absolutely correct, my lord. It is mentioned, my lord, the application for stay of the impugned judgment, your see the cause title.
Yes.
And subsequently, my lord, the judgment and order on a single was stayed.
State by which order?
In this also, my lord, the order, the 11/5/2018 order, although I have not got the order, but it is mentioned that where is the order is 11/5/2018. order 9. Only so, to show me lord 11/5/2018. In the online also, my lord, it shows that 11/5/2018, but it is not uploaded. In the online also, my lord, 11/5/2018, the order is shown,
Which says, what does it say?
but the order is not uploaded, my lord.
Not uploaded. But where's the stay of the,
No, the stay order was passed on, my lord. By the order dated. Order 26/8/2019. It was
order passed in miscase or the,
no, just checking up, my lord. 26/8/2019.
26/8/2019,
This is passed, my lord, in WM, my lord.
WA.
My lord. I have one copy, if your lordship may permit me, my lord. I'll pass it.
No, it's here. It's available here. It's okay. It's here. 26/8/2019.
My lord.
Honorable Justice A.K. Goswami was the presiding judge
My lord.
with Justice Chaudhary. Until further orders, operation of the impugned judgment order dated so and so remains suspended. So the writ appeal was 333 of 18
My lord,
in the principal seat,
my lord.
which has now been renumbered as
1 of 23.
1 of 2023. Now, regarding the IA, in the file we see only 3 orders.
My lord,
There are only 3 orders in the IA. IA 1902 of 2018. 2618 says, due to paucity of time, we are unable to take up the matter. List the case tomorrow.
my lord,
Then, order dated 15/6/18 says, list again on 26.
my lord.
Then, one more order, 6/6/18. It says, Dr. Saraf, so and so, so and so, so and so. As prayed for, list the case on 15/6.
Now, IA, my lord, on the basis of the IA, the judgment and order has been stayed. My lord, the IA, the prayer is that to stay the judgment and order of one single judge. That order has been passed in the writ appeal.
Was there no order in the writ appeal? I mean, no prayer in the writ appeal for stay?
For stay, I think, stay prayer was there.
Why did you have to file another IA
IA
to get stay?
बाद में किया ना? Main writ appeal में
Yes, in the interim,
in the main writ appeal,
in the interim, Lordship, my father pleased to stay operation of the impugned order dated so and so.
I think in the writ appeal, my lord, the prayer was not there.
No, it is there.
In the writ appeal.
Yes. The date of the order of the learned single judge is
23/3/2016,
23/3.
my lord,
23/3/16.
my lord.
Then what is this 10/12/6/15?
10/12/2015 is the letter, my lord, by which my lord, it was said at page 29,
29 of the writ appeal.
my lord, IA,
IA.
that is letter by which it was said that since the 2 years period the award has not been passed, as such the proceeding lapses.
Page
29.
29. No, this is your writ appeal, isn't it?
My lord.
Why should you pray for stay
My
of
lord,
this?
in fact, the writ appeal was filed by someone else, and there were a lot of defects in the writ appeal that we have to amend the writ appeal, and the prayer had to subsequently made. There was no condonation. We have to file a condonation also. A lot of.
Okay. So basically, writ appeal was to challenge the judgment of the learned single
But
judge. That should have
here
been there. Instead, 10, 12, 15 is there, which is basically in your favor.
My lord.
You say that we cancel the draft award because it is beyond the
In
time
fact, that was challenged by
lapse.
the petitioners in the writ petition.
Exactly.
But the writ appeal was preferred, my lord, in mechanical way, my lord.
Okay. So the IA had to be brought in.
My lord.
IA was not invited by the court.
Well, IA was invited because they lost him. I am not getting the order. But it says, my lord, that because when we made a prayer for stay, then the court said that you file a IA narrating all the facts of the case along with the prayer for stay of the order in appeal.
That is in which order?
No, that is 11/5/2018. I am not getting the order, my lord.
Okay, 11.5, which you just said.
My lord.
But there's a reference here in this order,
Yes, my lord.
21/6/18.
Where is the order?
Without condoning the delay and without admitting the appeal, question of staying the judgment under appeal may not arise at this stage. However, today's order may be brought to the notice of the learned single bench dealing with contempt case number so and so.
Thereafter, delay was condoned.
This order was passed in which case? In IA, okay. In IA 1902.
My lord.
1902 is before us. This is not for condonation of delay. This is for stay
My lord.
of the impugn judgment as well as the contempt proceeding.
Absolutely correct, my lord.
Delay condonation was in different case, different IA.
A different case for condonation. A different condonation, my lord, application.
Yes, there's a different condonation application. So there's one writ appeal, two IAs.
My lord.
One IA was delay condonation that was disposed of as allowed.
My lord.
Second IA is regarding this stay of the contempt proceeding and the stay of the judgment,
Absolutely correct, my lord.
and which is, I think, still alive.
Yeah.
So there were some defects in the appeal.
My lord.
So that had to be rectified by way of the IA, condonation as well as the stay.
My lord.
Okay.
Now, my lord, the issue arising before your lordship is that there are two issues.
Yes.
One, I will satisfy your lordship that if the award is not approved as it is, then there is no award. Now, in view of the subsequent developments by which the learned single judge passed the order in page 99, my lord, a committee was formed to scrutinize the claims, and 100 something claims were found to be bogus. Coordination committee. And your lordship may see the learned single judge directed, just if your lordship may see the 199,
Page 99.
the 11th part of page 102. Para 8, my lord.
Yes.
From the submission of the learned government advocate, it is clear and apparent that the submission of so-and-so, the learned senior counsel for the petitioners, has forced inasmuch as the fact of overlapping is some extent admitted by the state respondents. Keeping in view the statement made in the affidavit in opposition and the grievances of the petitioners, this petition accordingly disposed of with a direction to the respondents to take into consideration the faulty process which inadvertently cropped up in the final compensation list and completed the process both for identification of the actual affected persons and subsequent dispersal of the compensation to the affected person within a period of 2 months from the date of receipt of the copy of this order today, along with the copy of so-and-so.
Yes.
So the court directed me not to examine the faulty process for the determination of compensation, because the many claims were false, not genuine, and thereafter to disburse the amount within 2 months. Now
Yes.
this judgment has attained finality. No appeal was filed against this judgment.
Okay.
Now, after this judgment, my lord, the process was determined and it was found, my lord, by way of an additional affidavit, my lord, we placed before the court, which was filed on 3/5/2024.
Yes.
At page 6, my lord, we brought on record
Revised.
the revised, my lord, the draft award in view of the direction issued by the single judge, my lord, in the subsequent proceedings. And at page 8, your lordship can see
Approval.
approval, and the amount was 6 crore something. Now, this amount has been disbursed and accepted by the claimants without any grievance.
The previous assessment was how much?
12 crores,
12 crores.
some plus solicitation, my lord.
The revised estimate or revised draft award,
6 crores something.
6 crores. This is with the solation
No,
or without solation?
without solution, no? Is it without solution, no? Solution.
Solatium has been calculated separately or not calculated?
With solution, my lord. Your lordship, you see page 13 of this additional affidavit.
Solatium 30%, 12% interest.
My lord.
So figure comes to 6 crores.
My lord. Earlier, my lord, the 12 crores something was there. And apart from that, the interest and all those things, amount was 20 crores something. In your, my lord, the IA, you'll also find it page 17. The amount is mentioned.
Page 17.
Page 17 of the IA, my lord, for
The earlier IA.
my lord.
There was, what is there?
The 12 crores was the total amount determined.
Ah.
And out of that, my lord, this one, interest and etc. After that, the amount was determined to be 20 crores, 51 lakhs,
With Solatium interest.
my lord.
That has been now
Revised.
revised to 6 crores, 11 lakhs.
My lord.
But the covering letter says 6 crores, 11 lakhs, but the next chart
My lord.
comes to 10 crores and all that. How come it does not tally? Calculation sheet,
This is for
it says 10 crores. Village recalculation statement.
my lord, this is total, my lord, you'll also may see in the page 13, part E to N. We are concerned E. This was total for part E to N. And in this case, we are concerned with only part E. So the part E amount came to 6 crores something. my lord.
Where is the total?
My lord.
Page 15 says total this much.
Total, my lord. This is page 13, you'll also may see at the top, part E to N.
E to N, yes.
And here we are concerned with only part E
In which
in the present case, my lord.
we are concerned with only part E.
Part E, my lord.
Has it been specified here in this covering letter?
Income
Approval of
part E.
draft award.
इनका लिखा हुआ से थे
Page 8 does not say part E.
well याचे जी असे कुंतु असे the 10 process no 6 crore कुंतु असे which are the items कितना होता है इसका अमाउंट फिर फल किए मत कैसा
I think we should fall back to page 6,
My lord.
annexure 1. This will throw some light.
Page 6, my lord.
Page 6, annexure 1.
My lord.
6 crores 11 lakhs figures there.
My lord.
Then also as per section 23 LA Act, additional amount of 30% so and so requested. Hence, total amount of award, solatium interest and 2% contingency,
My lord, absolutely correct, my lord.
10 crores.
My lord. Now, out of this amount, my lord, certain people have accepted the amount, and some people have not accepted. We have given the affidavit also, placing that the person's claimants have accepted, and some people have not accepted. Now, the question is not, my lord, at this stage, my lord, in the writ appeal present, the two questions are arising, my lord. One, that the award earlier is no award. I place before your judgment. But in view of the subsequent judgment of this Honorable Court, whereby this Honorable Court directed that the earlier award you should redetermine by the basis of finding out the false claims, etc., and thereafter disburse the amount, which order has attained finality. And on the basis of that order, the recompensation has been redetermined and approved and also offered for payment, out of which number of claimants have accepted the amount. We have given a chart also that who are the persons who have accepted the award, and that judgment, subsequent judgment, is not under challenge. That has attained finality. Now, in view of the subsequent developments which has taken place in view of the passing of the subsequent judgment by this Honorable Court, my lord,
Yes.
in my humble submission, my lord, instead of going into the validity of the earlier award which is challenged in the writ appeal, since the learned single judge of this Honorable Court in subsequent proceedings has directed that the earlier award should be rectified by way of deleting the faulty, and it is correct, my lord, that by fraud nobody can claim any compensation. Now that exercise having been done, the amount having been disbursed, the matter has, my lord, in fact, now in my humble submission, has been concluded. Because assuming, my lord, the learned single judge earlier order which is in the challenge before this in the writ appeal. Now, by the way of the subsequent judgment, that has been revised by deleting the faulty claims. Now, if it has been revised by faulty claims, deleting the faulty claims, and the amount has been paid on the basis of the recalculation which has been made, then, my lord, to examine again the validity of the award, because the subsequent judgment is not in challenge, that is attained finality, and that cannot be disturbed also. The subsequent, my lord, the judgment of this Honorable Court by learned single judge has attained finality. Now, if, my lord, at this stage, we say that no, earlier award was no award, then the subsequent judgment which has been passed, on the basis of which the recalculation has been made and the amount has been disbursed, my lord, that judgment having attained finality, that cannot be given effect to, which has already been given effect to, because there was no appeal.
Let us see the judgment of Justice Dekar.
My lord, you'll also find it page
Page
98.
in the IA, isn't it?
IA, my lord.
99.
99, my lord, the main judgment starts. You'll also permit me, I may read the facts, my lord.
Yes, please.
Para 2. The petition number 1 is a coordination committee which was formed for the purpose of keeping a strict vigil so that the compensation is given to the genuine landowners whose lands are affected by the construction widening of the so-and-so road, and to check the false claims made by the numerous landowners and the genuine affected persons be compensated without any further delay, and also for expediting the process of construction and widening upgradation of the said so-and-so road. In this petition, the petitioner challenged the impugned award number 3 of 2014, the same award, which was made by the respondent 3 in connection with the project for upgradation widening of the so-and-so road, which is approved by the respondent 2. It is submitted by the senior counsel that the purpose of the upgradation, the respondent 2 issued a notification under section 4(1) of the so-and-so act. Subsequent thereto, the necessary steps were taken for acquisition of the land, both sites and existing road so-and-so which can score. A list consisting of the various affected persons was also prepared by the said PWD department. On the other hand, after the issuance of the notification, the Revenue Department also undertook the process of spot verification as per the instruction of the respondent 3. Against the said project of upgradation and widening of the so-and-so road, 2 sets of verification came in existence. The petitioners being agreed on the act of issuance of the draft award, wherein the respondent 3, instead of accepting a single spot verification report out of the 2, had merged both the said 2 reports pursuant to the decision of the respondent 1 and 2. Due to the merger of the spot verification reports, the amount in compensation demanded from respondent 4 has gone up to rupees 20 crore something only. In spite of the said draft award and the same being approved by the respondent 2, no payment or compensation was disbursed by so-and-so till date. An inquiry being made by it came to notice that the petitioners said the numerous number of names of the persons had been shown in the common list after the merger of the 2 claimants through no damage could be caused to their land so-and-so. On the actual verification of petition, it came to notice that the list of the names of the persons shown therein at different locations are all reliable. In other words, most of the names included in the said list would not be affected if in any manner the project is temporarily widening of the said so-and-so. In order to check the wastage of public money, the name of the compensation persons who are not affected in the said project, the writ petition filed with the following prayers. Paragraph 6, my lord. So-and-so learned counsel submits that the respondents owe a duty to check unnecessary wastage of the public money, and as such, the petition undertaking to verify the names of the persons affected owing to the said project with the help of the respondents to so-and-so.
This, the writ petition 10 of 2016 was not brought to the knowledge of the learned single judge.
Well, this was subsequently, my lord.
No, correct. The writ appeal you have filed today is
My lord.
against the judgment in WPC 10 of 2016, saying that the award is okay.
No, that was not
Late.
what it's, my lord, some other
And when
counsel.
this writ petition was filed by this group of interested person,
My lord.
public spirited persons, that thing was not brought to the
It
knowledge.
appears so, my lord. Some counsel were there, other counsels.
Government counsel was same.
Well, maybe my lord. But this was, it appears that this was not there. I don't know whether in the writ petition. it
So
was-
there's no reference of the earlier judgment.
No,
It just says that there's some faulty process,
my lord.
a faulty assessment,
My lord.
and government is looking into it. And
They
court
admit-
say that you go ahead, go and look into it and take a decision.
Then the court said, my lord, that you redetermine and they have to make payment within 2 months after redetermination. At para 8.
To take into consideration the faulty process and inadvertently cropped up in the final compensation list, and this was the compensation. So, this does not, in a way, dilute the order of the learned single judge in WPC 10 of
No,
2016.
the learned single judge order as such has not been diluted. But the amount which was there, that the learned single judge says that ki faulty whatever are there, you determine, and thereafter we will also see the Milord says that this disposition disposed of with a direction to the respondent to take into consideration the faulty process which inadvertently cropped up in the final compensation list and complete the process both for identification of the actual affected persons and subsequent dispersal of the compensation to the affected person within a period of 2 months.
Correct. So the
that
first
has been
order,
done.
the first order says that this is not lapsed. Award has not lapsed. You pay. Second writ petition says that there's some faulty process. Court said, okay, you take into consideration to the faulty process and pay. So
Now-
basically, ultimate net result is you pay.
So ultimately we are paid.
You verify and take out that faulty process and pay. You have paid. And today you say that, no, in fact, the award had lapsed because it was not accepted in toto.
My lord, now my submission is
Now, well, whether that will be open at this stage, you have said that this has become attained its finality. Nobody has challenged. State also has not challenged. In fact, you have complied. You've taken out the faulty process and you have redetermined, and this is the amount. 11 crores with solatium and all that, and you have paid to those who are interested. Those who are not interested, they have not taken. So can we go back now and say that, okay, let us again examine whether the award has lapsed or not.
That's why, my lord,
We cannot lose sight of the other order, which we have just read now. This is there.
that's why I am submitting for lordship that in view of the changed circumstances,
Yes,
perhaps my argument also will have to change.
yes, probably.
Naturally, my lord, when the earlier also it was approved because there was false claims, my lord, 20 crores was the amount. And the ultimate it was found that the double, triple, the person, same person's name were there. And all have been, my lord, verified by committee, determined, and number of persons have accepted the amount. Accepted or not accepted, that is a different thing, my lord. But in view of this judgment, which has attained finality, the award was revisited and the amount has been paid. Now, under such circumstances, if today I say that there was no award, then the subsequent judgment of this honorable court that you re-verify and make the payment within 2 months, which has been paid, and has been
That question will come to you. You say that there is no award, then I'll say, why? You have complied with the subsequent judgment in continuation that award, you have verified and you have determined and you have also paid.
Well, that's why I am submitting for
So
lordship.
you cannot put your feet on both boats.
Well, I am submitting for lordship that at this stage, in view of this, and in view of the subsequent judgment, and in view of the fact that it has been redetermined, and the faulty whichever was there, that has been all deleted, the amount has been paid. There were 167 bogus claims were there. And about 10 crores amount was reduced.
67 out of
167 out of total. I'm just giving you
167 is bogus.
bogus claims. So my submission before lordship at this stage will be there. After all, the writ is the equitable jurisdiction. The lordship is after all lending, my lord, the equitable jurisdiction must be there. Lordship will not direct that the false claims who are there faulty, they should be paid. It cannot be. So at this stage, my submission for lordship will be there that subject to your lordship consideration, that this writ appeal may be closed by taking into consideration the subsequent order passed by the non-single judge, subsequent verification which has been made, and subsequent payment which has been made. On the basis of that, without going into the correctness of the judgment of the non-single judge earlier one, the writ appeal may be closed.
So give me the figure, 167 bogus out of total
Out of-
how many
I'm ju-
claims?
I'm just finding on that.
And who has been paid? How many people have been paid and who have not been?
That chart is given, my lord, in one additional affidavit, more is there, my lord, which is filed on 18/11/2022. Running pages will be, my lord, of the writ appeal, 164.
In the writ appeal.
My lord,
I don't think we follow that running page here.
oh my lord. This is dated 18/11/2022.
So whatever readings are filed last comes on the top. It's not paginated.
ಇದು ಕಿಮ್ಮತ್ claim ಅಸಲು. Hmm?
Not there, is it? It's not there.
My lord.
Okay, sorry. Writ appeal is there, then your additional affidavit filed on 3rd May is there,
This
then
is
your
intellectual
compilation. No other documents.
This is in fact IO interlocutory application, my lord.
In the IA?
This is IA number 1902.
Yes.
In,
1902 is here.
this is there in that, my lord, the additional affidavit is there.
Additional affidavit.
On 18/11/2022.
Oh, yes, additional affidavit.
Here you'll also find internal page. What is internal page?
18 November in the IA, brother.
अरे इसमें नहीं है नंबरिंग यार. Running page below 170 internal page.
Running page, yes, correct. It is there.
You'll also
One-
find the chart. Actual page receipt, my lord.
What is the page number?
With the,
184. An extra one.
not before that, my lord, the pleading itself, page 170.
170.
My lord.
No, affidavit starts from 173. And the chart is in the affidavit. Mine is 179, page 179.
You know, an actual one is the actual page receipt, all those things.
Yes,
Prior to that, my lord, the pleadings you'll also see.
there's a chart. Comprising of how many serial numbers? Total 36.
My lord. These are respondents.
These are the ones who have received the amount.
Now the bogus, which were there, you'll also see page next. The
Where?
bogus, whoever claims are there, claim 10, 11, 12.
Where?
In the chart, my lord, which I have given in the page 170. In the affidavit.
180. Bogus claims.
My lord. The next page also, you'll also find the bogus claims.
You said 167 bogus claims,
My lord.
but these are only
167, my lord, of the different claims in respect to the respondents. Respondents were 36.
36 respondents.
Claims were different, my lord.
Claims were much more.
Claims were, my lord, 160, 200 claims in respect to different lands.
Okay.
And the detail, my lord, the,
Respondents, you mean the writ petitioners?
my lord,
There were how many? How many?
36.
36 writ petitioners.
And the detailed report, my lord, which was prepared by the, how it has been, copy was there. That is in the IA, page 103. IA for the stay, which was there, my lord. (103A) and 104 it starts.
Yes, this is the report.
My lord, and 104 you'll also see the report, detailed report, along with all the documents and papers. And you'll also see page 105,
167 numbers.
you mentioned below.
But the total claim is not there, isn't it?
My lord,
Total number of claims is not there.
total number of claimants is not there, my lord, claims is not there,
Only 167 bogus claims.
bogus claims, which is mentioned in the chart, my lord. Subsequently, all annexures which I have annexed, my lord. From page 107 onwards.
What does this 105 say? It weeds out 167 numbers of bogus claims, reducing the compensation amount by so and so.
My lord,
And then
the proposed final amount for disbursement of the actual person is 5 so and so. So and so the team will also,
this figure is what? The proposed final amount for disbursement.
my lord, this is, my lord, 6 crores something was the, my lord, the false one. So out of 12 crores, if you reduce 6 crores something, then it comes to 5 crores, it's 68 lakhs.
Okay, okay. So ultimately, how much was approved? The recalculation you had shown me.
With solution, I think 10 crores.
With solution 10 crores. That was in which page?
So that is in the additional affidavit in the writ appeal, page 6.
Page 6. Here also there's slight variation.
My lord.
Out of 12 crores, if 6 crores are minus, then 568, 34, 327 remains to be
Right.
paid. But the revised draft award speaks about
595.
595.
Well, it says including 16 lakhs, 27,944 being 2% contingency.
So 568 plus 116 lakhs will come to 595.
My lord.
So this page 105, 5 lakhs 68,000, I'm sorry, 5 crores 68 lakhs is without the contingency.
My lord.
Okay. There's still some shortages.
It appears to be so, my lord, some amount.
84, 94, about 10, 11 lakhs still missing.
6 crores something has been approved, my lord, at page 8. In any case, my lord, the amount being more,
6 crores something is with the contingency.
my lord.
But there's no approval of the solatium interest?
My lord,
No approval in respect of solatium interest?
solution interest approval कहाँ है?
Dr. Saraf,
My lord.
your main thrust of the argument in writ appeal was that the award has lapsed
My lord.
because of so and so.
Absolutely.
But then after one more writ petition came, one more direction from the court, you examine whatever faulty process is there calculate and pay. Nobody brought to the notice of the court that we are filing an appeal, we are not happy with this. So the order was complied with. So as on today, payment has been done. That argument perhaps
That's
may
why
not hold the field.
in view of the chase circumstances, the prayer has also to be modified and the Milord,
There was a gap of 2 years. You see, from the judgment of the learned single judge, the early one. 2 years down the line, only that order came. Within that 2 years, nothing happened.
nothing happened.
On some sort of speculation was going on, what is wrong, what is right, complaints were there. Finally, somebody came to the court. Although they are not the landowners.
The writ appeal was preferred in the principal seat, the writ petition was filed in the IGL bench.
Correct.
So perhaps that may be also a reason. But in any case, the state was there, must be knowing
State
it.
was there. State was there.
So they should have pointed out.
State was there.
But in any view of the matter, my lord, under these circumstances, present circumstances, my lord, the prayer and the relief has to be modified according to being the equitable jurisdiction. Because the court cannot direct that those who are not genuine and faulty persons, they should be paid. And once the single judge has directed that this should be deleted, and that I attend finality, in my humble submission, my lord, the writ appeal may be disposed of in that line, my lord.
Can you just show us that particular ground you have taken in the appeal? How many grounds are there?
Yes, sir. Writ appeal. Effectively.
Page 8. Nothing much.
There is nothing, my lord, in my, if I admit, my lord, the way it has been prepared. General, everything, my lord.
Anything else, Mr. Sharaf?
In my humble submission, this is the situation, and in this way, my lord.
Would you still like to point out that judgment of the Supreme
Yes,
Court?
yes.
Show us.
Copy, Diva. This 2006-2.
2000,
6-2
62,
SCC 416.
416. Paragraph
The paragraph mainly will be from 24 and 25.
24, 25.
My lord. Paragraph 25, my lord. Just from 5 and 6 line from top.
Yes.
It starts from the approval of the award may take some time.
Yes.
The approval of the award may take some time, and it is not known to the collector as to when the government will approve the award. However, after the award is approved, if there is no alteration in the award, he is required to notify the party concerned about the award. He may do so, fixing the date so and so. Thereafter, may skip over, my lord. Just 7 or 8 lines from the bottom, my lord. The award which has already been signed by the collector becomes an award as soon as it is approved by the government without any alteration.
Without any alteration, does it have any further clarity in this judgment?
No, nothing is there. It says as it is if it is approved.
So can we draw the presumption that if it's not as it is not an award?
Well, that, according to me, well, earlier the submission mine was on that line only. But I have to change the line in view of the subsequent judgment of this.
Okay.
I'm applying.
Yes, other side. We'll hear other side.
May I please your lordship?
Yes.
I'll attempt to assist this honorable court by submitting 5 points,
Yes.
which I will be confined to. Number 1, grounds of appeal taken by the learned appellant. Then number 2,
Mr. Soirama, you are
My-
appearing for which respondent?
respondent, my lord. All of them except Mr. Dinari appear, my lord,
Which is that?
which is two to 5. That was reflected in order 26/6/2024, your lordship.
Okay, you tell me. Ms. Dinari, you are appearing for which respondent? More than one.
Yes, more than one. Yes.
Okay, you just write it down somewhere and give it to us. Yes, you may start your submission.
Your lordship may kindly come to page number 9, my lord, of the appeal memo.
Yes.
The appeal ground was taken here in number 2 to 7, my lord. Here, my lord, 2 things was passed by the honorable single judge in disposing WPC number 10 of 2016. He quashed, number 1, the observation made by the Law and Judicial Department. And based on the observation made by the Law and Judicial Department, the state government had taken a decision saying that, yes, 2 years have lapsed, so the award need to be cancelled. So that order was communicated to the collector, my lord. Then the appeal, in the appeal memo, we find that the only order which set aside the observation made by the Law and Judicial has been challenged, my lord. The order which set aside the decision of the state government which cancelled the award has not been challenged. That means if this appeal was accepted as it is, the order which set aside the decisions of the state government cancelling the award will still remain. If I may kindly repeat, my lord.
Yes.
The order passed by the honorable single judge has set aside 2 things.
Yes.
Number 1 is the observation made by Law and Judicial Department saying that the award was not passed within 2 years.
Okay.
Then based on that observation, this state government had taken a decision. And the decision was that the award was not made within 2 years. So that decision was another factor which the honorable single judge has cancelled, set aside. So here in this appeal, only the part,
Learned single judge has set aside only the
two things, my lord.
2 things.
Yes, my lord.
One is,
decision-
one is the decision of the Law and Judicial Department. The other is the notification by which the Law and Judicial Department's advice was acted upon.
Correct,
2
my
things.
lord. Correct, my lord.
So both were set aside.
Yes, both were set aside. my
But
lord.
the appeal has challenged only one.
One, yes.
Which one?
The observation made by Law and Judicial Department, my lord.
Only that.
Yes,
Okay.
that is the one thing, my lord.
Okay.
Then, my lord, in In para number 3, it was stated that the Honorable Single Judge
No,
declared
just
that,
a minute. Can you be more specific?
my lord,
Observation of the law and judicial department.
that we have to come to the decisions of the Honorable Single Judge, which was
No, you have
impugned.
referred to the grounds of
That
the
will
appeal.
be in-
Grounds of writ appeal. Is
Yes,
it
ground
mentioned
of
anywhere?
writ appeals is in page 9.
Yes, we are at page 9. So which ground? Ground number?
Ground number 2, for that the Honorable Single Judge set aside the impugned letter dated 3/12/2015. This impugned letter dated 3/12/2015 is the observation of Law and Judicial Department,
Yes.
my lord.
So this is challenged.
Yes, this is challenge.
What else?
Then
Where's the notification?
there was no challenge to the decisions of the state government.
What is the decision of the state government? Is
State
the
government, yes, it is fine in the
document is available?
yes impugned order, my lord. That is in page
Page
46. The relevant part will be in page 53 of the appeal memo, para 12, my lord. May I kindly read?
Yes.
Para 12, page 53. In view of the reasons stated above, the observations of the Law and Judicial Department, white letter so and so, dated 3/12/2015, which is reflected in the letter dated 10/12/2015 issued by the Undersecretary to the Government of Mizoram, Land and Revenue Cell Department is set aside. The letter dated 10/12/2015 issued by the Undersecretary to the Government of Mizoram, Land Revenue and Settlement Department is also set aside. So, these decisions taken by the state has also been set aside. And the opinion of the Law and Judicial Department has also been set aside. Whereas in the appeal, only the order, only the opinion of the Law and Judicial Department has been challenged.
Opinion of the Law and Judicial Department is
Dated, my lord, 3/12/2015, my lord.
which is reflected in ground number 2.
Yes, my lord.
And what is the notification date? Or the letter date?
notification, the decision of the state is 10/12/2015, my lord.
This is only a letter.
Letter, but you know, my lord, this court knows very well that an opinion can be taken from the Advocate General or from the Law Department also, my lord. But the state is not binding. He can also take a different opinion, my lord. But when that he has taken opinion, then that becomes a separate decision, my lord.
Okay, your basic point is that two things were set aside by the
My
learned
lord.
single judge.
Yes.
They have failed to challenge one of them.
Yes.
That is the outcome of the decision taken to comply or to accept the advice of the Law and Judicial Department.
Yes, correct, my lord. Correct,
We'll just take break for 5 minutes and come back.
my lord. Chicken. Your Lordship, we'll continue from page 9, the appeal grounds.
Yes.
Para 3 and para 4, it's quite similar. I'll just read out, Your Lordship. For that, the Honorable Single Judge declared that the draft award number 3 of 2014 to be veiled in law by holding that the Government of Mizoram Land and Revenue Department cannot be said to be cancelled without examining the power of the government as to whether it had the power to cancel such approval once accorded. Number 4, for that the Honorable Single Judge failed to arrive at the conclusion that the impugned letter dated 15/10/2015 cancelling the earlier approval of the draft award is void, illegal and without jurisdiction, and the impugned judgment is passed without taking the relevant points of executive power into consideration. Here, Your Lordship, it speaks the power of the state government to cancel the award which was already approved. Yes, they have the power to cancel the award, though it may be approved, but that is subjected to the statute. Section 48 of the Land Acquisition Act gives power to the state on which they can cancel the award already approved.
Okay.
Yes, then when they cannot cancel, the award has also been stated in section 48. If the award has not been taken possession by the state, then yes, of course, it may be approved, it can be cancelled. So in this case, whether the landowner's land have been taken possession by the state has to be examined, my lord. So I may take your kind lordship to the IA, that stay application, page number 65 to 68.
Yes. Status report.
Correct, my lord. This was addressed to the secretary by the ENCPWD. In paragraph number 1, that is in page 65.
Yes.
I would come to para number 3. The work was started on dated 24/9/2011. So even before the acquisition proceeding has been started, possession was already taken by the state, my lord. So after taking possession, they cannot cancel the award, my lord. Because section 48 of the Land Acquisition Act has put a bar to the state powers. Then I may also refer to para number 12, your lordship, the report that may be found in page 66.
What is that relevant section which puts a bar?
48, your lordship, of LA 1894.
Section 48.
Your lordship.
You have a section 48 with you? Just read.
Completion of acquisition not compulsory, but compensation to be awarded when not completed. In subpara 2, whenever the government withdraws from any such acquisition, the collector shall determine the amount of compensation due for the damage suffered by the owner in consequence of the notice or of any proceedings thereunder, and shall pay such amount to the person interested together with all costs reasonably incurred by him in the prosecution for the under this act. Let's just do it first.
Was it your case before the learned single judge that you cannot cancel the approval given for the award? Even if you do it, You need to give us compensation for having taken over our lands.
That was not the issue, my lord. The only issue before the honorable single judge was that the observation act, the state take a decision on the observations of the law and judicial department. So, after examining with the provisions of law, that the state decision was wrong. That is why we are approaching the honorable single judge, my lord, honorable single bench, my lord.
Your challenge in the writ petition was to the withdrawal of the approval.
Correct.
That much only.
That much, my lord, my lord.
So court said that it is not lapsed because the section 6 was notified on 7/6/2013,
Yes, my lord.
and on the date on which the impugned cancellation was passed, 2 years had not lapsed,
Yes, my lord.
or when the draft award was
Approve.
approved. So the advice given by the Law and Judicial Department, according to the learned single judge, was not correct. 2 years had not lapsed. So you pay.
Yes, my lord.
Now state has filed an appeal challenging the decision.
Yes, my lord.
But then, as you have already heard, one more writ petition came up,
Yes.
wherein nobody said anything about the earlier round of litigation, and court passed the order saying that, okay, if you are finding some faulty process, take into account that faulty process and take pay the compensation. Today, the faulty process has been rectified according to the state, and some payment has been given to those who accepts it. So, is it required to go back to that stage now
Your lordship,
to see whether the correction, the recalling of the approval is correct or not? So many things have happened since then.
yes. That is one aspect. The different aspect is this. What order have been passed by in WPC 167 and how it was executed by the state. Now, if one submits before the honorable court that there was a bogus claim, it draws one attention. But that allegation, the correctness of the allegation can be tested by the materials available before this honorable court, my lord.
In this writ appeal,
Yes, my lord.
no, 167 has not been questioned by anybody.
Anybody, yes, my lord. But
You have not filed an appeal. State
correct,
also has not filed an
correct.
appeal.
that appeal has not been met due to the reasons that no appeal was necessary. Because if there is a double claim of the compensation, yes, it has to be corrected at any point of time, whether by the court or by the collector, my lord. Now, the question before your kind lordship is that how the order was executed, that is a different aspects, my lord. Now,
Which order?
there was a 167, my lord, that which was supposed to be PIL 167, which the learned appellant is referring. Now, there was an allegation from the appellant that there was so many bogus claims. Yes, this court understands the role of the landowners in making land acquisition is very limited. All the verification, conducting spot verification, making assessment and making award does not belongs in the hands of the landowners. How can there be a bogus claim, my lord? Now, if we go to that record, which we have already come across, date of possession was already taken on 2011. Formation cutting was done. When formation cutting was done, the landowner's land was already destroyed. Their crops was already destroyed. Their house was already destroyed. Now, that is not from the side of my submission. It is all on the record, my lord, which I may read out for your kind notice, my lord. Now, after destroying everything, on 2018, based on the order passed in 167, they conducted reassessment, my lord. What will they find, my lord? Nothing. That was already damaged.
So, you have not questioned that by filing necessary process. Now, how can you come to that issue in an appeal filed by the state? This is not your appeal. This is appeal by the state. They have come to the limited question saying that learned single judge was wrong because it had lapsed. Why it lapsed? Because the composite award as it was not approved. Piecemeal it was approved, some part was not approved. So that's why that cannot survive. But then in the meantime, that 167 came. Rightly or wrongly, learned single judge says, you do this. They have done it. And some of them have taken payment also, landowners. Some have been left out or some have been denied payment. For them, whatever may be available to them, remedy would not be in this writ appeal. It would have been elsewhere.
Yes, that is true. Then,
So
yes.
we should not, linger on this issue. I think if you all are aware of the developments, I think the issue to be considered here lies in a very narrow compass, not beyond that.
All right, I accept that, Your Lordship. Then, my lord, if the submissions of the appellant is accepted in toto, then the allegation that the Bogus claim it seems to be admitted by this honorable court, my lord. Because with due respect to the appellant,
Court
my
has
lord,
not admitted. Court has said that, okay, you say that there's some bogus claim. Okay, right, fine. You take into consideration that aspect, do the needful, and pay the compensation. Court did not say that this much are bogus, this much are correct. That was left to the authorities to take a call on that,
yes, my lord.
isn't it?
Yes, Your Lordship.
So
Correct.
that is why if you feel that you have been termed as a bogus claimant or that you have been left out, immediately you should have come up saying that how have you done this? It's not possible. Work started in 2011, just like you pointed out just now. After digging up everything, how do you say there is a bogus claim? That will be in appropriate proceedings, not by this appeal.
Yes, award. Yes, my lord. The award was made on 2014 and was approved on 2015. Then there was an intervention of this honorable court order that this is a valid award. Then without quashing the award passed by this honorable court saying the award is valid, then they made another revised award, my lord. There was no direction of this honorable court to make a revised award, my lord. The only portion which was directed was to correct which was overlapping, my lord. That much, my lord. Now,
Okay, so that is why I had indicated earlier. If that was what, according to you, was to be done and not done, you could have done something about it. You have not done anything. Nobody has raised any voice on that 167. It has attained a finality.
I accept that, my lord, because according to the direction given by the single bench 167, if they have acted, it is okay. But now, how they have executed is a different manner. Now, on that result, they are pressing this honorable court to set aside the learned single judge order, my lord, which said that is a valid award. Now, they have also equal opportunity. Reference application was already pending since 2015. If there is a bogus award, then we are having a similar opportunity to adduce evidence to the court. Now, instead of saying their merits before the reference court, they are making a revised award, my lord. Then even before the direction given by this honorable court, they have already started revising the award. That is found in the record, my lord. That is found in the judgment of the honorable single judge, my lord. If I may take your kind lordship, my lord. To the order passed by honorable single judge, that is found in page number
99.
Yes, 99. Para 7, my lord. Mrs. So-and-so, government advocate, on the other hand, pointing paragraph number 5 of the affidavit in positions of the respondent number 1 to 5, submits that the respondent are in favor of reassessment of the actual damage of the private properties belonging to the genuine private person. And in fact, it is submitted that the said process of identification had already started and to some extent completed. Even before a direction was given by the Honorable Single Bench, they have acted on their own volition. Now, these all actions of the state is within the operations of the earlier single bench order, which declared the award to be valid, my lord. When the award is declared to be valid by the single bench, it is binding to the state, my lord. It's like they are sitting upon the order passed by the honorable court, my lord.
So let me repeat again what I said. They were sitting over the court's judgment, but nobody pointed out a finger that they are sitting over the court's judgment, which led to passing this order. Okay, you were not a party to that writ petition. You could not have pointed out that. Fine. But the moment you came to learn that there was something going on here in view of some order, you should have done something about it. That was not done, so it has attained a finality as on today.
If I may, your lordship. Yes, if the order remains as it is, it
Which
affects
order?
it, that WPC 167,
Yes.
it does not affect us. But if the revised award has been accepted by this honorable court, then it will be too much painful for us, because that revised award was not made with the in consonance with the directions of the honorable court, my lord. It will automatically binding to us, that revised award. And that revised award was also made during the operations of the honorable court order, saying this award is valid award. Now, if my lord may kindly come to the reasons for appeal. The real reasons of appeal is in the record, my lord. Earlier there was a decision of the state saying that there will be double land road, but due to the policy change by the government, maybe for the better reason, they decreased the size of the alignment. So during that period, land was already damaged. So they said this land was not much required. We only required 18 feet. So thereafter, they take some steps to minimize the compensation award. That is how these cases crop up. That is in the record, my lord. So after destroying everything, after I have lost my house, then I have to shift it to a distant places. Now on 2018 they came,
Mr.
and you are not in
Rama,
their
you know
work.
very well, see,
Yes, my lord.
if you have this kind of hardship, there are process available to you, how to go about it.
We are in the reference court, my lord. But if the revised award is accepted as it is, then all those reference case pending before the reference court, that will be infructuous, my lord.
How?
Because
How will it become infructuous?
this revised award was made on 2018. The earlier award which was approved
Merely
was,
because this court takes into cognition the revised award,
yes, my
your
lord.
reference case becomes infructuous?
Yes, my lord.
How is that?
Because that reference application was made on the basis of 2015 award. There are many reference cases pending, awaiting the order of this honorable court. Then if this revised award is accepted, then it will all be infructuous.
So in the revised award, are you included?
No.
You're not included.
Some I am included, some I am not included.
Okay.
Some of the landowners are included.
So are you remediless against that?
Yes, my lord,
How do you say that?
because as I have pointed out earlier, when the formation cutting was done, my house corner was then destroyed. Then I cannot sleep in the road with my family. Then I have to borrow some money and move a bit further. Now on the revised award on 2018, when they came, they said that no, you are not within the road alignment. So I was deleted. They made the allegation that we are bogus, and they became the judge also. They finalized everything and prepared that revised award.
So you filed necessary process. This is an appeal by the state.
Yes.
Whatever grounds taken here, we are limited to that.
Yes.
We don't
Yes.
intend to expand
I'll
the
argue
scope.
on that point, my lord.
We don't intend to scope and widen the scope of this writ appeal by going to every nook and corner to examine what was right, what was wrong.
Yes, my
That
lord.
cannot be done.
Yes, my lord. The appeal grounds are mentioned in para 9 of the appeal memo, my lord.
You have read already.
Yes.
We have seen
So
it.
we are saying that there is no ground for setting aside the order passed by the honorable single bench, because there is no illegality in the order passed by the honorable single bench. It was in consonance with the provisions of law, and it was in consonance with the settled principles of law, my lord.
Okay. All right. Anything else?
Yes, my lord. Another point, my lord.
Yes.
Now, the state has deleted me, saying that your land was not now required. Then a settled law was there. When the land was already taken possession, then the area which was used, the leftover part, shall be put to public use. And if there is no use for public purpose, it has to be public auctioned. Now the state intention is, we only want this part, you take this part. That cannot be applied. That will be against the settled principles of law.
Okay.
My lord.
That's all?
My lord.
Yes, Mr.
Well, first of all,
Mr. Dr. Sharaf, will you hear?
oh my lord, I'm sorry.
There's one more. There are two groups.
My lord.
Wait, please, Your Lordship. Your Lordship
Can
has,
you tell us now, you are appearing for which respondents?
Actually, I had filed my power 9 and 22. But 9 and 22. May it please Your Lordship, I'll come to the WPC 167. And
No, before that, we would like to know for whom, which respondent you are appearing.
19 and 22.
Only two.
Yes. I filed my power only for them.
Yes.
And with regard to the WPC 167 of 2017, Your Lordship, you know that here the direction is para 8. The direction of this case. Kindly see page 102 of the interlocutory application IA.
Yes, we are at para 8.
Yeah, 10, yes, para 8.
Yes.
From the submission of the learned government advocate, it is clear and apparent that the submission of Mr. Such and Such, the learned senior counsel for the petitioner, has forced in as much as the facts of overlapping is to some extent admitted by the state respondent, keeping in view the statement made in the affidavit opposition and the grievances of the present petitioners. This writ petition is accordingly disposed of with a direction, kindly see, Your Lordship, to the respondent to take into consideration the faulty process which inadvertently crops up in the final compensation list and complete the process both for identification of actual affected persons and the subsequent disbursal here and the subsequent disbursal of the compensation to the affected persons within the period of 2 months from the date of receipt of copy of this order passed today, along with the copy of the writ petition with the annexes annexed to it. So, my understanding here, Your Lordship, the previous award is not set aside or cancelled. So that award, those who are genuine has to pay from the award. But now, how they process is that all the verification is done, and they have recalculated and revised. And likewise, Your Lordship, as you know, I have filed a writ petition against the action of the state respondent with regard to this 167. That case was pending before this Honorable Court, WPC 37 of 2019. And in that case, this Honorable Court passed an order that to wait for this outcome of this appeal. So we are waiting for this outcome of the present appeal. So in that case, Your Lordship, kindly see the affidavit filed by the appellant, that is writ appeal number 1 of 2023, the State of Mizoram versus Lalliansunga, that affidavit which was filed. Here it was annexed the revised estimate, I should say revised recalculation of the state land. Your Lordship, here I'm concerned with the Bukpui village. They are the claimant 136 and the revised also 136, but they have deducted the writ petition 37 of 2019 plaintiffs, 5 of them. And the previous award, they were awarded 40 lakhs something, but in the revised, it becomes 20 lakhs. So being aggrieved by that, I have approached this Honorable Court, which was pending before this Honorable Court, Your Lordship. Your Lordship got the affidavit filed by this appellant. Here, kindly see an annexure 8. Annexure 2, page 8.
Yes.
Here, Bukpui, 136. Yes, previously also 136, the claimants. And after recalculation, Your Lordship, even though the total amount is increased, but with regard to the petitioner in writ petition 37 of 2019, it was deducted. It becomes like that. So they have no identify which is a bogus claim. Only they have to see only bogus claim. But those who are genuine land passes also recalculated and revised the award. So this is the action of the appellant, even though the direction is to identify the actual affected faulty process. And those who are genuine, they have to pay within 2 months. But they've revised all of them, even the genuine, those who hold the genuine passes. So landowners.
The
And even
area to be acquired has been decreased.
decreased. That's why I have filed my writ petitions. Some are increased. For your notice, Your Lordship, previously 136 award is, it becomes 266,91840. That is 2 crore 66 lakhs. And the revised, it has come, that is the revised. The old one is 252. So some claimants has awarded more than the previous one, and some are decreased, some are increased.
Probably that will be taken into consideration in WPC 37 of 19.
Yes,
It can be taken into consideration in that case.
yes. The order is
How
that.
do you go into that aspect in this case?
Yes. Your Lordship, the thing is that in that case, this Honorable Court passed an order to wait for this outcome of this appeal. Yeah. Yes. If the revised award is accepted, it will cover all the, because it's wrongly done that, not the judgment of the judgment and order of WPC 167 of 2017. Here it's only directed to identify, yes, and disburse the compensation to the affected from the award, previous award. Yeah. Now they are making fresh award and recalculate it, reassess, and if the action of the appellant, where they have make a recalculation, reassess and all, Your Lordship, the judgment of this Honorable Court, where here the appeal is filed, and where the WPC 10 of 2016, even here, the single bench directed the respondent to pay the compensation award to the petitioner as per draft award number 3 of 2014. Not to revise, to pay. But it comes 167, WPC 167 directed to identify faulty process and do the needful only. It's not directed to make a recalculation of reassessment or revise. Nothing is, no direction is there. So they have appealed against this order dated 23/3/2016 in WPC 10 of 2016. And they, in the ground of appeal, if you see the ground of appeal, only that the advice of the law and judicial is not challenged in the writ petition, only that. Yes. That is the challenge, the main challenge. So with regard to the challenge made by the appellant, Your Lordship, the kindly see para grounds for appeal, para 8. Here, Your Lordship. Number one, I read from number two, ground number two. For the Honorable Single Judge set aside the impugned letter dated 3/12/2015, which was neither on the records of pleadings nor it was challenged in the writ petition. The quashing of the said letter is void, illegal, and without jurisdiction. With regard to this advice of the law and judicial, it's a part and parcel of the challenge made in the writ petition, government decision. That government decision is based on the advice of the law and judicial department. So it is a part and parcel of the decision of the government. And number three, for that the Honorable Single Judge declared that the draft award number 3 of 2014 to be, valid in law by holding that the government of Mizoram Land and Revenue Department cannot be said to be cancelled without examining the power of the government as to whether it had the power to cancel such approval once accorded. For that, the Honorable Single Judge failed to arrive at the conclusion that the impugned letter dated 15/10/2015 cancelling the earlier approval of the draft award is void, illegal, and without jurisdiction, and the impugned judgment is passed without taking the relevant point of executive power to consideration. For that, this is clear case of non-application of mind by the Honorable Single Judge about the relevant facts and materials into consideration. For that, the writ petition is allowed by the Honorable Single Judge without examining the constitutional validity of impugned letter 15/10/2015. So, as you know, Your Lordship, the judgment is not only set aside the cancellation of the award, it's also directed to pay the award in accordance with award number 3 of 2014.
Dated 15/10/15. What is this? Mrs. Dinari?
Yes, I'll come to that, Your Lordship, in the
Constitutional validity of the impugned letter dated 15/10/15.
yes.
What is this?
Where judgment upon English. Judgment. I have not seen 15/10 in the single judgment.
So it's one of the grounds. Dr. Saraf, what is this? It's 15/10/15. Can you throw some light?
I'm also trying to search out. I must admit one thing, Lord, out of the records, not to taken on records. But in my so many years practice, I've never seen such a casual drafting of the writ appeal on behalf of the state. My Lord, although appeal is a continuation of the writ proceedings, only 2 paragraph grounds may be sufficient.
Correct.
But the way it has been drafted and filed, my Lord, what I can say, my Lord, nothing more. But I will submit before also, my Lord, that irrespective of whatever grounds are there, the one ground is enough, my Lord, that the learned single judgment is not illegal and liable to be set aside. That itself is a sufficient ground. After all, this is a continuation of the writ proceedings.
Correct.
In our court, in our Guwahati High Court, the system is that writing all the facts. Otherwise, in Bombay, etc., only simple 2 pages only grounds and the appeal is filed. No pleading, nothing. No statement facts.
Then the records are called?
Records are called, and on the basis of that, the appeal is admitted. Here we have to
It
file,
saves a lot of time and energy, isn't it?
here we have to file everything, facts, everything in writing.
Yes.
Those are not there. Grounds simple, whatever grounds are there.
Facts of the case, then
What points which arose for decision and all those things.
points taken by the petitioner, points taken by the respondents,
Those
points which
already-
arose.
Those are already then the judgment of single judge. Why they are necessary? In any way, my lord, we have to go by our system.
Yes. So we'll assemble at 2.
Yes.
Meantime, just try to find out if there's any document which of this date, 15/10/15.
Yeah, you have checked it before also, we didn't find
We
it.
didn't find.
Maybe mistakenly left it.
Any letter, my lord, the constitutional validity of the letter cannot be there. So, my lord, the letter may be illegal or something with there, but constitutional validity of any communication, I feel so, my lord, that one cannot say that constitutionally validity we are challenging of any communication.
Okay, I think we are more or less done. Ms. Dinari will complete your submission. Perhaps Dr. Sirao will have a short reply. Then we can end the matter. But since it's a break time, we'll come back at 2.
Yes, yes, my lord, you will also be check.
Instead,
go. तरफ देखो गैप है इधर में पुश करो और हाँ yes
Yes, may please your lordship, that with regard to the writ appeal number 1 of 2023, affidavit filed by the appellant, we kindly see the Annex 2, page 8.
affidavit filed on 3rd May
Appellant, yes.
3rd May 24
I don't know the date. I have not.
page number
Page number 8.
8
Approval of draft award number
Yes.
3. Your Lordship, the annexure of this, annexure 2, kindly see here, recalculation statement.
where recalculation yes
Yes. So it seems that here all the genuine claimant are included and recalculated, reassessed. Verification is done and reassessed. Like Bukpui, here 136. From Bukpui village 136. So in Bukpui village, I have a writ petitioner, 5 of them. In previous award, they are calculated some 40 lakhs, and this recalculation, it becomes 20 lakhs. And kindly see again page 11. Second para.
yes
Your Lordship got it?
Yes.
The district collector, in pursuance to the direction of Honorable High Court in connection with writ petition 167/2017 of 19/3/2018, carried out verification by a team comprising of PWD, Land Revenue Department, leaders of Coordination Committee, Serkan Bakarot, all VCP concerned village, along with the project and representative of DC scholarship under supervision of additional DC scholarship. Here, nowhere mentioned the petitioner or the claimant, excluding. And next para, award number 1 of 2018 is therefore prepared in accordance with all formalities signed by representative of all concerned and prepared final list of draft award for approval of the government, which superseded all other awards in connection with Serkan Bakaro. So this is not the direction of the WPC in 167 of 2017. It's only the direction is to identify the faulty process, and those who are genuine landowners should be given within 2 months from the award already passed.
okay
So it seems that
what is the name of this award revised draft award 1/3 of 2014 or award number 1 of 2018
yeah, this is confusing. This is
18 award number 1 of 2018 after revision it has become 1 of 18 earlier it was 3 of
3 of
14.
2014.
yes okay
And the Lordship, now I'll come to the appeal. I have mentioned the appeal ground. So they have said that law and judicial letter is set aside without challenging. They have said that opinion. So the annexure Page 35. Appeal. From the appeal memo, kindly see page 35. This is the impugned letter.
35.
Memo of appeal.
Yes, 35.
Yeah, you got it, Your Lordship.
Yes.
To the Deputy Commissioner, Kolasip District, Kolasip, Mizoram, draft award number 3 of 2014. Sir, in inviting a reference to the letter number stated above, I am directed to reproduce the observation of Law and Judicial Department White letter such and such. The matter has been re-examined in the Law and Judicial Department and returned with an observation that the instant proceeding was started by issue of notification under Section 4.1 of the Land Acquisition Act 1894 on 14/3/2012 and declaration under Section 6 issued on 7/6/2013. Hence, the instant proceeding is not stayed by notification 5/1/2015. However, as 2 years have elapsed without an award being made under Section 11 of the Land Acquisition Act 1894, without the proceeding being stayed an order of a court, the entire proceeding have thereby lapsed as per section such and such. Hence, there remains no further scope for approval of the draft award or reassessment thereof, and acquisition proceeding may be taken up only as per and after the promulgation of the new State Land Acquisition Act directly under active consideration drafting of the state government. As per the above observation of Law and Judicial Department, the draft award number approved by this may be treated as cancelled. So, being aggrieved by this order, the petitioner, the respondent herein, approached this Honorable Court in writ petition 10 of 2016. So, the learned single judge set aside this order dated 10 December 2015 along with the inside one, Law and Judicial Opinion 3/12/2015. So what I mean to say is that Law and Judicial Opinion, just opinion, they can reject nor accept by the government. So they accepted and cancel. So it is part and parcel of the order dated 10 December 2015. So there's no harm set aside the opinion of the Law and Judicial Department. That is my point, number one. And what my, yes, and this writ petition 167 2017 is filed during the pendency of writ petition hearing, writ appeal hearing. So the one who filed appeal is state government. So knowingly that appeal is pending and they process and recalculated, reassess, and pass an award 1 of 2018 against the order of the WPC number 10 of 2016, which was pending disposal before the writ appeal court, appellate court. So this is the scenario. And Your Lordship, what my understanding is that if this Honorable Court dismiss the writ appeal, award number 3 of 2014 is 10. And there is no harm complying writ petition order 167/2017 order. What I mean to say that what is made in the 2014 calculation, everything is there. And during the pendency, order 19/2018 in WPC 167/2017 is passed. So the order is, we are not achieved by the order of 167/2017. It's only say that pay who are a genuine claimant, identify affected person, those who are affected. I'll read out the Lordship again. Kindly bear me. Next year. Judgment in order. Page 98 IA. Stay application.
Page 99.
Yes. Page 102, operative portion. Your Lordship, I'll again read this. This writ petition is accordingly disposed of with a direction to the respondent to take into consideration the faulty process which inadvertently crop up in the final compensation list and complete the process both for identification of the actual affected persons and subsequent disbursal of the compensation to the affected person within a period of 2 months from the date of receipt of copy of this order passed today, along with the copy of a writ petition with the annexure. So my understanding is that the state government should identify the faulty process, and like Bogus claim, they have to identify, and they may delete it from the award. Those who are genuine, they have recalculated their award, and assessment, new assessment is made. Everything is made fresh.
Yes.
So at this stage, if this Honorable Court accept award number 3 of 2014, there is no harm to take action in accordance with the direction made in 167. Those who are genuine should be paid in accordance with award number 3 of 2014. Maybe some are more increased, some are decreased, but it should be 3 of 2014. And it will come to judgment and order in WPC 167, wherein here the direction is identify the affected person in the final compensation list and complete the process for the identification of the actual affected person. And this verse here, it said, no, the faulty process which inadvertently crop up in the final compensation list. From the list, they can delete those who are bogus claim or whatever faulty process. Now, in the reference court in scholarship, case is pending. So in there, you cannot pay this and this, number such and such, because they are bogus claim, not affected. And they can do like that. So there's no harm. There's no aggrieved by the claimant, the order passed in the WPC 167 of 2017. Because of that order, the state government, state respondents take up action but wrongly they have made recalculate, reassessment. Even the genuine past owner, they have decreased or increased the award. This is the action of the respondent. So my submission is that, Your Lordship, the prayer is, if you read the ground of appeal, only they have said this honorable single judge has set aside impugned order which was neither on the record of pleading nor it was challenged, but it is in the records, the law and judicial opinion. It is in the impugned order, inside the impugned order. That is set aside. It is part and parcel of the impugned order. I should say impugned letter. So in other ground, if you read, there is no important ground, I feel that.
All right.
So there is no, here in single bench, direction is that the respondent should pay the, here I'll read out to Your Lordship kindly the last direction.
Which direction?
Direction of the impugned single bench order.
Yes, impugns, the single bench has
Yeah,
interfered
It
with
did.
both the contents of that letter as well as that letter itself.
yes.
We have seen it.
Relative part, Your Lordship, here. Para 13, I'll read out here. Para 13, 46. Page 46 of IA. Here, the respondent are directed to pay the compensation awarded to the petitioners as per the draft award number 3 of 2014 within a period of 6 months. So, as per, yes, here as per draft award number 1 of 3 of 2014.
Okay.
So there's no legality or grounds legality in the order passed by single bench. So this honorable court may uphold this judgment and order passed by single bench. Okay.
Yes?
I'd like to submit those judgments of the apex court. The purpose of section 11A, why it was brought to LA 1894. That is Caliapan versus State of Kerala, 1989, volume 1 SC 113. Since the learned appellant has submitted judgment regarding that 11A.
Please repeat, 1989.
1989, volume 1 SCC, page 113.
Paragraph.
Paragraph 3.
This is regarding.
This is regarding 11A. Paragraph 3. The contentions of the petitioner, yes, my lord got it. It's page 116 maybe.
What is 11A otherwise?
11, where the intention of the legislature has been pointed out by the Honorable Supreme Court that the statement of object and reason attached to the bill introducing the Land Acquisition Act 1894, by which section 11A was introduced into the act, it was stated that the pendency of acquisition proceedings for a long period often cause hardship to the affected parties and renders unrealistic the scale of compensation offered to them. It was further stated in that it is proposed to provide for a period of 2 years from the date of publications of the declaration under section 6 of the act, within which the collector should make his award under the act. If no award is made within that period, the entire proceedings for the acquisitions of the land would lapse. So the period prescribed 2 years is to protect the landowners from long delay of compensation, my lord. That is the legislature intention. And one more judgment, my lord. That is Government of NB versus Saeed Akbar, 2005, Volume 1 SCC, 2005, Volume 1 SCC, page 558.
Paragraph.
Para 10.
This is again regarding section 10, 11A.
That after taking position, the government cannot withdraw from the land acquisition order. As by virtue of section 16, it stood to the state. Shall I kindly read out para 10?
Yes.
It is neither debated nor disputed as regard the valid acquisitions of land in question under the provision of the Land Acquisition Act, and the possessions of the land had been taken by virtue of section 16 of the Land Acquisition Act. The acquired land has vested absolutely in the government, free from all encumbrances. Under section 48 of the Land Acquisition Act, government could withdraw from the acquisitions of any land of which possession has not been taken. In the instant case, even under section 48, the government could not withdraw from the acquisition or to reconvey the said land to the respondent, as the possessions of the land had already been taken. Now there was another reference. In view of the admitted position that the land in question was acquired under Land Acquisition Act 1894, by operation of section 16 of the Land Acquisition Act, it stood vested in the state, free from all encumbrances. The question emerges whether the government can assign the land to the erstwhile owner. It is settled law that if the land is acquired for a public purpose, after the public purpose was achieved, the rest of the land could be used for any other purpose. In case there is not other purpose for which the land is needed, then instead of disposal by way of sale to the erstwhile owner, the land should be put to public auction, and the amount of fetch in the public auction can be better utilized for a public purpose, envisaged in the directive principles of the Constitution. Now, another judgment, my lord, 1982, Volume 3 SCC 227, page 227.
Paragraph.
Paragraph 3, my lord.
This is regarding.
This is regarding, my lord, as there was allegations of bogus claim, my lord, it's disputed facts. So there is an appropriate forum, a statutory forum under section 18, reference court. So we are both the parties there. If they accuse the landowners as bogus, then they can say it in the reference court that no, we cannot pay this. Due to this, it is not affected. So they have the right to approach the reference court. So I'll come to that portion, my lord. Paragraph 3, the state, there can be no doubt as to the competency of the reference under section 18 of the Act, which read as follows. The state government department on which behalf or the company for which acquisition is being made, or any person interested who has not accepted the word or the amendment thereof, may, by written application to the collector, require the matter to be referred by the collector for the determinations of the court, whether his objection to be the measurement of the land, the amount of compensation, the amount of cost allowed, the person to whom it is payable, or the apportionment of the compensation among the person interested. It is clear upon the plain terms of the section that reference may be had not only at the instance of the person interested who has not accepted the word or the amendment thereof, but also at the instance of the authority acquiring land, on whose behalf or the company for which the acquisition is being made. The contention that the award made by the land acquisition officer being an offer made on behalf of the state government, the reference by the collector under section 18 of the Act for reduction of the amount of compensation awarded by him was not competent, cannot be accepted. In Mohammed Hasnuddin versus State of Maharashtra, one of us observed, while it is true that the collector in making the award under section 11 acts as an agent of the government, he is making a reference to the court under section 18 acts as a statutory authority. It is well settled after the decisions of the Privy Council in Estra versus Secretary of State for India that the legislature has assigned to the collector the position of an agent of the government while making an award under section 11. No, though the award made by the land acquisition officer is in the nature of an offer, but it is subject to the right of the state government to ask for a reference under section 18 of the Act. Under section 18 of the Act, one of the questions that may be referred by the collector for the determination of the court is as to the objection to the amount of compensation awarded. If the state government is dissatisfied with the award made by the land acquisition officer, it may apply for a reference under section 18 for reductions of the amount of compensation. The reference made by the collector under section 18 of the Act as to the amount of compensation was therefore competent. Both the points must be therefore answered in favor of the respondent. The reason for pointing out this judgment is that, my lord, if they feel aggrieved that the amount is too much, then they have the right to file a reference, my lord. Then already they are parties. Then they can also submit that this amount is so much for this reason and for this reason. So the other parties can also agitate that these are my right, these are my right. Now, as submitted by my learned sister, my lord, setting aside this appeal will not prejudice the state, because in the revised award, which they find that some person was a bogus claim, they can submit to the reference court that, no, we cannot pay to this person because this and that, for this reason. We had the High Court judgment, 167 was there. So there was a direction that only affected person has to be paid. So you are not affected for this reason. So they had the remedy there. So the other party will also submit his merit. No, I am here, this is my position. So without contesting the allegation, if the amended award, if the revised award is approved as it is and upheld the appeal, so much prejudice would be caused to the humble landowners, my lord. So my humble prayer is to set aside this appeal and leave the order passed in 167 as it is, my lord. Oh, yes, dismiss the appeal, my lord. Yes, my apology. Yes, that much, my lord.
Okay.
I'm obliged.
Dr. Saraf, anything to point out?
My lord, there are things you pointed out. As I can understand from the submissions made by my learned friends, that they are not aggrieved by the order passed by non-single judge in WPC 163.
167.
They are not aggrieved. Now, they say that on the basis of the judgment of the non-single judge in 167, state should have found out the genuine, the whatever process, faulty process, everything, they should have done it. Now, if that is accepted, then the state has done it. Now that, if according to the respondents, my lord, that is wrong, that is not correct, genuine persons have been left out, then as correctly pointed out by my learned friend, section 18 is there. Who is aggrieved now? 167, once they accept, that becomes final. And on the basis of that, the compensation is determined. The genuine persons or whatever persons are there, they are found out and the compensation determined. Then the aggrieved can only be the respondents who finds that their claims, genuine claims, have not been considered, they have been left out, or by saying any other reason, my lord. Then in 2018, the interlocutory application was filed and the reassessment order and draft order, final order was also enclosed therewith. They were aware in 2018 itself. And the very fact that one writ petition was also filed before this Honorable Court, which is pending, challenging the revised one, that itself shows that some persons have approached this Honorable Court seeking legal remedies against the revised award on the ground that the petitioner being a genuine has been left out.
Yes.
If the other claimants slips over their right and don't avail the remedies available under the Act or by way of the writ petition before this Honorable Court, can at this stage they can say, no, the state should have taken recourse to section 18. On the other hand, they are saying that yes, the directions of the 167 by this Honorable Court, they should have been followed. Well, it is contradictory statements. If one says that 167 we have no grievance, and the state should have done as per the direction of this Honorable Court, then it may be, I don't say, my lord, it may be that the compensation which has been determined according to them, it may be wrong. Some persons have been left out, or some persons' compensation is lower or something. But what remedy is there thereafter? The remedy is section 18. Or, as my learned friend says, they approach this Honorable Court in one of the writ petition. Being fully aware in 2018 itself that the committee had determined and the amount has been redetermined, and accordingly the payments have also been made. If they don't challenge it, can at this stage they can ask this, request this Honorable Court to determine what is genuine and what is not genuine? Can this Honorable Court sit in the writ appellate jurisdiction and determine what was the land and what was not the land? It cannot be. If they would have challenged 167 and said that no, the learned single has no power and jurisdiction to issue such directions, I can understand. Once they accept 167, and today also they are saying we have no grievance against the judgment and order in 167. If there is no grievance against judgment and order in 167, they cannot have any grievance again also before this Honorable Court, saying that the competition was faulty. My learned friend again and again referring to section 48, okay, which is that if the land acquisition after the land has been acquired, if the acquisition proceedings are dropped, section 48. You'll also see subsection 2, section 48.
Yes.
May I read, my lord? Whenever the government withdraws from any such acquisition, the collectors shall determine the amount of compensation due to the damage suffered by the owner of the consequence of the notice on so and so, so and so. So, in case a land has been acquired, and after that 5 years, something 2 years, the government withdraws from the acquisition, then for the damages caused to all those things, the collector will determine the compensation 48. Where is the case? In the present case, that the acquisition has been withdrawn. Whether section 4, section 6 notification has been withdrawn. It has not been withdrawn. In case, my lord, by filing the petition under section 18 of the Act, they can show that our land was acquired, this land was acquired, but now it is not covered by this one, they can claim the compensation as per the provisions of the Act. But they cannot, my lord, request the writ appellate court and make it a reference court, section 18, to determine the compensation by taking all the objections against the award which has been vested with in section 18. Well, all the options, legal options, are open to them. And in fact, they have availed. One person has availed and approached this honorable court. My learned sister was saying that in the learned single judge order, it has been said that we are awaiting the decision of the writ appellate court. This honorable court can say that they can proceed on merit. The writ bench can proceed on the merits. And if the bench finds that no, the genuine claim of the person had not been compensated, the court will grant the compensation. Court will issue necessary directions. But that cannot be a ground. On one hand, my lord, some persons have accepted the compensation without any grievance. Some persons who have not accepted, they have not approached the court. In 2018, we filed an interlocutory application pointing out to them that this is the award. They have not approached for 6 years. One person approaches the court. One person who approaches the court itself means that the person who has aggrieved, he has approached the court for relief, the rest are not aggrieved. As you will see, there are backbenchers that one cannot sit behind and see that, let us see one case and thereafter I will do also. That the Supreme Court has also disapproved. One must assert to his rights, legal rights, before any forum. I don't say before this solo court, before the reference court, before any court. When they are aware of the impugned order, passing of the phrase award is a different cause of action. If somebody is aggrieved, and that was passed in terms of the direction passed by this honorable court, which has attained finality. Now, if they are aggrieved by that one, they have to initiate legal proceedings in accordance with law. Who stopped them today also, my lord? Although the question of limitation, etc., all that will be considered by them. But they cannot come up and say, after 6 years, 7 years, that this honorable court will condone everything and will say that now you proceed, irrespective of the limitations, whatever is laid down in the act. As you will also be aware, my lord, statutory limitations, whatever are there, that only can be condoned by the authorities on whom the power has been conferred or the power is there under the act. So, my lord, in my humble submission, I accept the submissions of the respondents, petitioners, that we are not aggrieved by 167. We have not challenged. Knowing very well in 2018, at least I take it, that if they are not aware, they were aware in 2018 that the order was there. They have decided not to challenge it correctly also, because the learned single judge correctly said that faulty process, whatever who are the land have been acquired, the interested persons, their compensation will be given. Any person who is not interested, compensation cannot be claimed. Can anybody say that I am not interested but compensation will be given to me? Learned single judge correctly said that those persons who are interested, landowners interested, according to grievance of petitioner, the petition disposed of, to take into consideration the faulty process, inadvertently corrupting final compensation, complete the process for identification of the actual affected persons. Now, whether anything wrong, compensation should be given to the persons who are not affected. Now, if they find then the actual determination by the state, they are the affected persons, they have been left out. Section 18 is there. They are saying the state should go. Why state should go? There is no question of going with the state in the section 18. The grievances of the landowners or the petitioners, my lord. Grievance is not of the state.
All right, Dr. Saraf, I think we have heard the parties.
And section, well, the three judgments which have been shown, section 11A, object, there is no dispute about the object. That was not the issue at all. Secondly, my lord, the other judgments which my learned friend said, one was section 18. So in my humble submission, my lord, those judgments are not applicable in the present facts and circumstances case. And about the, my lord, the order which was set aside, my lord, no, there is no, cannot be any two opinion that when a communication is set aside, because the order was passed on the opinion of the law and judicial department, law department. Now, if the opinion may remain in the file, who can stop it? That has no value. Once it was accepted, that has been set aside, then the opinion remains in the file, there is nothing doing. What will the value of the opinion? If the opinion was accepted by the government, that has been set aside, nothing remains. These technicalities, my lord, in my humble submission, the writ appellate court and the writ court, my lord, they don't go by the technicalities.
Okay.
So my
So we'll consider
humble
and
submission,
take a call.
I
Okay.
have already submitted for lordship. They're taking into consideration 167,
Please
judgment
write.
order passed by court.
Please write.
No, you can laugh. There is no doubt about it. I can also laugh.
Hart, Dr. A.K. Sharaf, Learned Senior Counsel, assisted by Mr. P. Borua for the appellants, Miss Dinari T. Azu, Learned Counsel appearing for respondent numbers 19 and 22.
Lordship, you have made a mistake filing the vaka. It should be my learned friend appear in some, but I should appear in respondent number 6, 7, 14, 15, 17, 18, 21, 23, 25, 26, 28, 29. Wrongly, you have mentioned.
If that is not indicated in the vaka, how do
yeah.
we record?
Yes, yeah.
We can just say Ms. Dinari T. Azu, Learned Counsel, and Mr. Lal Soirim, Learned Counsel,
Yes.
for the respondents.
We have no problem between us.
The rival parties have made their respective submissions. Hearing concluded, judgment.
Well, only thing, my lord, out of 36, some people have taken the compensation and there is no grievance. How? Just a minute. We have asked the papers also that they have accepted compensation, everything. How my learned friend can appear on behalf of them and oppose that, my lord?
Your Lordship,
They
this
are in a claimant.
this respondent, they are the applicant in the reference court. The
Reference
reference
court?
case is also pending.
That is a different thing. Reference court is
not a
different thing.
different thing. This is a similar thing.
No. Reference court is nothing. In this
No,
in this
it's a
court,
statutory forum.
after accepting, well, that is a different thing. Enhancement or compensation, anything. But those persons who have accepted, how that can be said that no, they are coming up and challenging that one.
Lordship, here,
No,
my
no.
name is there.
They are the respondents here. This from serial number
by
1
name.
to 36.
Well, out of
36,
36, my lord, after the judgment of the 167,
Yes.
compensation were determined and some of the respondents have accepted. There is no grievance.
This is not this appeal is not against challenge against the PPC 167. Don't mix
No,
up.
I'm not saying that.
Who are the respondents who have accepted?
In the lecture I've given, my lord, at page 170.
No, you give us a list. You prepare a list.
Well, I will
Out of these 36
Yes, my lord.
respondents,
Yes, my lord.
if there is anybody who has accepted
Yes,
the
my lord.
award,
Yes.
you just give it in writing.
My lord, it is there in the chart itself is there, my lord. If your lordship just finds, my lord, the interlocutory application.
They have received the compensation. So if they are not
Interlocutory application 18/11/2022. File on.
they can appeal also.
Where the
There is
interlocutory?
no bar.
But they can appeal. I don't say at all.
Your Lordship, in this similar matter, one direction was passed by this court that a person can take those revised award without prejudice to receive the earlier award. That was a standing direction, no appeal was there. So it still stands. So that judgment covered the present respondents. That is in WPC 37 of 2019.
See, Mr. Saraf, if you say that some of the respondents have received the award,
My lord.
just give us the respondent numbers,
My lord.
name. That will be they'll suffice. That much we want to know.
My lord, certainly, my lord. Because certain person noted dissatisfied with the revised compensation amount and the amount was not received.
Hearing concluded, order reserved,
My
okay?
lord. I'll give a chart, my lord. I'm highly obliged to lordship for giving a patient hearing, my lord, and giving me opportunity
Kami what
to visit the IGF for the first time.
You must come again.
Nice
Lordship,
place.
may
my
I
lord.
kindly place the order passed by this court?
Yes, give it.
2 copies.
Compensation received by respondent. কাগজে লিখে দিদি
Item number 7.
বলাই দিদি আমাকে
May it please your lordships. My lords, this is a jail appeal. I have been appointed amicus, my lords. It is and through this appeal, my lords, the appellant is seeking setting aside of the conviction under 302, my lords.
302.
Yes, my
Okay.
lords. He's seeking that the
You are the amicus.
amicus.
And who's the PP appearing for this? Oh, you are there.
Yes, my lord.
Okay.
My lords, through this
How many witnesses are there?
my lords, there are 9 prosecution witnesses
9 prosecution witnesses and,
and
defense?
4 defense, my lords.
4.
4.
Okay.
Now, my lords, at the outset, what the appellant is saying is that, my lords, his conviction and sentence be altered to one under culpable homicide not amounting to murder. He says
304.
304. He says, my lords, that the act of the single blow using a knife to the left abdomen of the victim, my lords, which had caused the death, that was done in an inebriated condition. And second, my lords, that was because of a sudden fight which had occurred on that date.
Okay.
Your lordships, I'll take your lordship straight to the FIR. This is at page, my lords, page 1. Yes.
You're referring to which page?
Page 1 of the paper book, my lords.
1.
Yes.
FIR.
FIR.
Yes.
My lords, I'll read from the first para, my lords. I have the honor to state that on dated 12th March 2017 at 5:45 p.m. while I was on duty at Pozol PS, a telephonic information was received from so-and-so Secretary Village Council Court, Salrang Village, stating that on dated 12th March 2017 at around 5:30 p.m. one Lalroat Moya, son of so-and-so of Chaltrang village, was stabbed on his left side of abdomen by PC Sangluna, son of so-and-so, as a result of which Lalroat Moya was immediately evacuated to PHC Kohai and died on the PHC Kohai. Hence, self with party left PS for Chalrang village to inquire the matter. During inquiry, it is learned that on the evening of 12th March 2017 at around 5:30 p.m., one Lalroat Moya, 30, son of so-and-so, was stabbed on his left side of abdomen by P.C. Sanghuna, 53 years, son of so-and-so, by using a knife about 21 centimeters, as a result of which Lalroat Moya, 30, son of so-and-so, was immediately evacuated to PHC, Kohai, and died at PHC, Kohai. Inquest was conducted over the dead body and found injury mark on his left side of abdomen about 1 inch's length. Another injury mark was found on his back about half-inch length. No other external injury mark was found on the body. The dead body of the said deceased person was forwarded to MO CHC Kozol for holding post-mortem examination. 1 knife used by the accused to stab the deceased, 1 kameez and 1 sweater was seized in presence of witnesses by preparing seizure memo. So, my lords, this incident had occurred in 2017, and the accused, my lords, was 53 years as on that date. Today, my lords, he is due to turn 60 in the next month. So, my lords, the incident is that a left strike was made in the left abdomen of the victim. So, my lords, I will just take your lordship straight to the evidence, my lords, straight to the statement of PW number 1, my lords. This is the officer who had, my lords, lodged the FIR.
This FIR was lodged on 13.
No, my lords, 12th. This is, I'm sorry, yes, 13th. 13th, my lords. Incident is 12th March.
FIR was submitted by another police officer
Yes, my lords.
who had gone to the spot after getting the information.
No, my lords. Received the information telephonically. Thereafter, my lords had gone.
Correct.
Yes.
After the information, he had gone to the spot
Yes.
and he found these things
Yes, my lords.
and the FIR was lodged.
Yes, my lords. My lords, his statement is at page 6, my lords.
6.
Yes. My lords, from the statements of the prosecution witness, it will become clear as to how things have unraveled. Though I must say, this is a case of circumstantial evidence. No direct evidence is there, my lords. That is also recorded in the judgment. So, your lordships, if I may read PW1's statement.
Yes.
I know the accused person. On 12th March 2017, while I was at Kozol PS, I received a telephone call from Mr. F. Vanad Thanga, Secretary Chalrang, VC, to the effect that on the same day at around 5:30 p.m., the accused P.C. Sanghuna, son of so-and-so, murdered by stabbing 1 Lalroat Moya, son of so-and-so, the resident of the same village, by a knife. As soon as I received the report of the incident, I began to take necessary steps. I prepared a police party under my command. On the same evening after dinner, the police party under my command rushed to Chalrang village, the place of incident. Just before reaching the said village, we met one person who waved us to stop our vehicle. On inquiring the matter, the said person stated, "Mi cover with luma sa himna zongin police kapan ani karon in surrender don." Which mainly means, my lords, that he has surrendered before the police. By this time, I came to know that
No.
Yes.
Please translate the other part also for
Yes,
the
my
benefit
lords.
of my brother. Mika with Luma.
Yes, I have stabbed somebody. So
So in order to get protection,
Yes.
I have come straight to the police.
correct, my lords.
He has surrendered.
Yes, surrendered.
He's the accused person only.
Yes.
Yes.
By this time, I came to know that he was the person who committed the murder, consequent upon which I was proceeding towards the village. I made a plan that if the said person accused was kept under my custody, he would be saved from enraged family members of the deceased person. So I detailed one Sipai constable to hide him somewhere in the jungle, and he was also entrusted to keep the said person under arrest. I and the remaining members of my party proceeded towards Chalrang village and visited the place of occurrence. I found pool of blood on the place of occurrence. When I reached the residence of the victim deceased, I found him lying inside his residence, already dead. I conducted inquest over his body. I found cut injury on the left abdomen of the deceased of 1 inch wide, and also found cut injury of his back half-inch wide. I seized the weapon of offense, that is tsemte, meaning knife, of 12 centimeter long, 8 inches, from the library of Chalrang, YMA. My
Okay,
yes,
just a
my lords.
minute. Chalrang, it's a village,
Yes,
and the police station was at Khozol.
Kozol.
Okay.
My lords, page 7. My initial inquiry revealed that as soon as the incident occurred, the deceased was rushed back to Kohai PHC but was dead on the way. The deceased was taken back to Chalrang. My lords, your lordships may keep in mind that, my lords, the victim had died on the way, not at the spot of place of occurrence. Because, my lords, I will be trusting on the issue of intention only.
He was taken to the hospital,
Yes,
but on the way he died. So
Yes.
they brought him back again.
Yes.
Okay.
So, my lords, I'll continue.
Yes.
The deceased was taken back to Chalrang village. It was reported that no medical doctor was available at the said PHC at the relevant time, and I made an order that post-mortem examination on the deceased would be done at Khozol PHC. I sent the body to the Khozol PHC, and in the meantime I returned to Khozol PS for further necessary steps. When I reached my police station, I submitted suo motu FIR. NSI R. Lalrem Rota took up the case for further steps. The post-mortem examination was done on the following day at Khozol PHC. While performing my inquest, the deceased was wearing red color shirt and above it striped color sweater. My lords, the seizures in the exhibits, the most important is my lords, knife and the medical reports, my lords. Thereafter, in cross-examination, my lords, it is a fact that when I first reached the PO, the dead place of occurrence, the dead body was no more on the place of occurrence. It is a fact that I seized the weapon of offense from the hands of YMA who were gathering at YMA library building. The suggestion that the incident took place from sudden provocation as a result of the accused expecting respect from younger who did not pay respect to elders. No comments. I have no comments with regards to the above suggestion because I had no knowledge about the character or behavior of both the accused and the deceased. The suggestion that the incident took place without premeditation is denied. It is a fact that I could not recall whether the wearing apparels of the accused at the time I first met him was stained with blood or not. I could not say whether the accused body was stained with blood or not. When I seized the weapon of offense, it was still stained with blood. The weapon of offense knife was sharp pointed and rusted. My lords, may keep this in mind, my lords. Rusted and appeared to be old and randomly used. Thereafter, my lords, I will take your lordships to PW2, my lords. This is the closest witness to the incident. Again, not a direct witness or eyewitness to the scene, to the incident, but was closest in time, my lords. It at her residence was the place of occurrence.
Residence of this PW2.
Yes, my lords.
Okay.
That was the place of occurrence.
Yes.
My lords. My lords, I'll read. I know the accused person. I'm sorry, if I may take your lordships to page 10. This is the translated version, my lords. Page 10. Page 10. She knows the accused person. She lives in Chalrang village. On dated 12th March 2017 in the afternoon, PC Sanghuna, who is the, my lords, appellant today, Roat Moya, the victim, and Roat Saka came to her house and watched television. She believed that they were just hanging around. At some time, PC Sanghuna, Zosanga, and Roat Saka went home. And only Roat Moya, my lords, this is the victim, was there. So, my lords, 3 of them were there. 4 of them were there, actually. 3 people, including the accused, had left. And the victim stayed back. After around 10 minutes, PC Sanghuna came back to her house. He was at the door and said, Armoi Lotswa o'clock there, which means, my lords, the accused was calling out the victim, please come out. And Roat Moya, who is the victim, replied that he'll just light his smoke. At this time, she was inside her bedroom and she heard some thudding sound and she ran outside and saw Ruat Moya lying on his back and PC Sanghuna on top of him, just outside the door at the veranda. She saw a knife on the right hand of PC Sanghuna, and Ruat Moya was holding the right hand of the accused, and she saw blood on the knife. Ruat Moya said, "Min Sandru, min Vitanya," which means again, my lords, I've been stabbed, please help me. And she screamed. Hearing her scream, Rinfella and Mwansana, my lords, these two people, Rinfella and Mwansana, were passing by. They came over, took away PC Sanghuna's knife. Ruat Moya got up and make his way to his relative's house. So, my lords, after being stabbed, the victim seems to have had the life force to get up and go over to his relative's house. Ruat Moya put his hand over his injury and he shed blood on the road. And she saw him collapsing just inside the door of his relative's house. They brought him to the hospital but did not make it. Since she was a woman and she was in shock, she panicked and could not remember anything very clearly. My lords, there is one thing I must point out in this scene, in this series of events, is that, my lords, the evidence will show that alcohol was being consumed in this place. That will come later, my lords, I'll show. Not only was the accused indulging in alcohol, but so was the victim, my lords. Just wanted to point that out. I'll show in the later on, my lords.
See, one thing,
Yes,
there were three persons,
Yes,
PC Sangluna, Zosanga, and Ruat Saka.
yes,
Then, three persons.
yes,
Then again, this victim, Ruat Moya.
yes.
That means all of them,
Four.
in total, there were four. Four people were there, three of them left.
Left.
The victim stayed back.
Correct, my lord.
Later on, who came back?
My lords,
The appellant.
appellant came back.
Appellant came back, called him out, and stabbed him.
Yes, my lords. And the interval between the leaving and coming back was 10 minutes as per the PW number 2, my lords.
And this outside to help him,
Yes.
Rinfel and Mwansana
Mwansana. Yes.
were there.
Yes.
Rinfella is PW3.
Yes, yes, my lords. Mwansana, PW.
Mwansana is
PW4.
PW4.
Zosanga and Ruatsaka, my lords, they have not been made witnesses. They have not been produced.
Who are they?
My lords,
Oh, they were the one who left.
Yes, yes.
They didn't come back, isn't it?
didn't.
They didn't come back. So outside, after stabbing him,
Yes.
they came in contact with Rinfel and Mwansana.
Correct.
So their evidence will come later on.
Yes, yes. My lords, I just wanted to point out also, as per this statement of this witness, the knife was on the right hand of the accused. That will, my lords, is vital because cross-examination will show. My lords, I'll proceed to the cross-examination.
From where do you say that it was on the right hand?
My lords may have the my lords, the 10th sentence of the first my lords,
PW2.
PW2 only, my lords, of her statement, my lords. 10th line, my lord. She
From the
saw
top.
a knife. In the middle it starts. She saw a knife.
She saw a knife on the right,
Right
hand
hand
of.
of PC. So
Okay.
my lords, I'll then proceed to the cross-examination.
So what is the relevance
My
of
lords,
being right hand or
she's-
left hand?
Yes, my lord. She says that as per her knowledge,
Uh,
both the accused and victim are left-handed.
both accused
The
and.
accused and victim are left-handed. Dominant left-handed, my lords.
Okay.
So, my lords, because my lords, this the submission I'm about to make is that, my lords, intention would be clear if they had used their dominant hand. Apparently, the knife was in the right hand, and she was the first witness to be, my lord, to spot right after the stabbing had occurred. So, my lords, that is one I would like to put forth, rightly or wrongly, my lords. Cross-examination, my lords.
Yes.
I'll just take your lordships through that. It is a fact that when the accused came back to her house and called out Ruat Moya outside, she did not see the accused holding the knife. Again, my lords, there seems to be some contradiction, but while she was inside the bedroom and heard the thudding sound, and since she did not hear any sound of fighting, she assumed that it was the sound of something that fell over. After the accused called Ruat Moya outside, the accused did not enter into her house. As per her knowledge, both the accused and Ruat Moya are left-handed. She could not remember on which hand the accused held the knife when they fell over, and could not remember which hand of the accused Ruat Moya was holding. It is a fact that she did not witness the accused stabbing Ruat Moya. When Ruat Moya called for help, he did not mention who stabbed him, and did not mention that P.C. Sanghuna stabbed him. As per her knowledge, accused and Ruat Moya were very good friends, and she never heard them fight. She denied the suggestion that some other miscreant assaulted Ruat Moya. So, my lords, as per her knowledge, because the accused, along with 3 other persons, including the victim, they were good friends, my lords. Pertinently so, they were all together that very afternoon and seemed to be socializing, watching television, my lords. So no enmity, prior enmity as such. But then your lordships which has seen that he can't recall which the knife, which hand was being held, which left or right, my lord. So your lordships can discard that part. But I'll just point out this fact that there was no prior enmity. They seem to be good friends. My lords, then I'll take your lordships to PW number 3, who is the witness. PW number 3, my lord.
3.
Yes. Witness to the incident post the stabbing. Page 13 is the translated version.
Yes.
He knows the accused person. On 12th March 2017, Sunday evening at around 5:30 p.m., while he was roaming around outside, he was not far from Pipmwaki's house and heard her scream and then ran over to her house. My lords, Pipmwaki is alias for, again, my lords, PW number 2. Just pointing that out. When he reached the place, he saw P.C. Sanghuna lying over Ruat Moya inside the house. And he heard Ruat Moya screaming, "Hey, Min Vitanya," which means, "Hey, he has stabbed me." P.C. Sanghuna was still holding a knife. He took him by the neck and pulled him aside. During this time, his friend Muansana arrived, and he took the knife from P.C. Sanghuna and rescued Ruat Kima and tended to his injury. From what he saw, he believes P.C. Sanghuna stabbed Ruat Moya on the left abdomen through his back, while P.C. Sanghuna was lying over Ruat Moya. Their heads were outside the door and their feet were inside the house. While they were preparing Ruat Moya to get him to the hospital, P.C. Sanghuna threatened him, saying, "Nangpo khani duem," which means, my lords, do you also want to be stabbed? After a short while, Ruat Moya succumbed to his injury. As per the character of P.C. Sanghuna, he knew him to be a normal person, but who often consumed alcohol. My lords, cross I will again read. It is a fact that since the accused P.C. Sanghuna is older than him, he does not know him very well. It is a fact that he does not know if the accused is left-handed or right-handed. It is a fact that when the accused was lying over the victim and when he took him aside, he did not see the accused holding a knife. He only heard the victim saying "Minvit," which means "he stabbed me," but did not heard him say "P.C. Sanghuna Minvit," which means P.C. Sanghuna, the accused, had stabbed me. That is what was not stated by the victim. It is a fact that when they reached the place of occurrence, only the owner of the house, Pipmwaki, was there. My lords, at this juncture, one thing which must be, my lords, which must be noted is the fact, my lords, that the accused seems to be an alcoholic of sorts. He consumes alcohol often, as per his own statement. Because, my lords, in the medical, there seems to be no examination done as to whether he was inebriated that day, unfortunately. Now, my lords, PW4, who is Lal Mohansana, who the PW number 3 refers to, my lords. His statement I'll just take your lordships through. I knew the accused person. On 12th March 2017 at around 5:30 p.m., I was on my way to home, and when I reached the house of Lal Ramhuaki, I heard a desperate shouting for help from the house of P. Lal Ramhuaki. I rushed to her residence, and when I reached, I saw the accused upon the victim Lal Ratmoya, who was lying on the veranda floor. I saw the accused with a long knife on his left hand. I could notice that there was incident of assault. I snatched the knife from the hand of the accused, and the knife was stained with blood. I saw the victim Lal Ratmoya seriously injured, and some person took the victim to CHC Khozol. And later I came to know that the victim succumbed to his injuries just before reaching the CHC Kohai. After the incident, the victim scrambled weakly from the place of incident. The victim scrambled weakly from the place of incident. Cross-examination, my lords. I'll just read out, my lords. It is a fact that I did not saw the accused stabbing the deceased. It is a fact that I did not see the accused and the deceased fighting on the occasion complained of. It is a fact that I snatched the knife and put it on the veranda of Piram Huaki's house. It is a fact that I never knew whether the knife was stained with blood or not, and even after I grabbed and snatched the knife, no blood was stained on my hand. It is a fact that I did not know whether the accused was receiving injuries or not. I do not know whether the accused has passed criminal record or not. My lords, PW 5 and 6 I would not read because they are seizing witnesses of the seizure of the articles, my lords. 5 and 6. Seizure witnesses.
Yes.
My lords, PW number 7 is the medical officer. And her opinion is in a statement, my lords. I'll read. At the relevant time of incident, this is at page 17. My lords. At the relevant time of incident, I was posted at Khozol CHC as medical officer. The deceased in the present case was brought to me by police for post-mortem examination with an application on 13 March 2017 at around 9:40 a.m. I started post-mortem examination of the deceased at 10:05 a.m. and completed the process at 11:45 a.m. and the deceased was disposed of to the police. The following were my findings. There was a deep laceration measuring 1 inch length in the upper abdominal wall below the medial side of the left lower costal margin. The muscle of the chest wall was lacerated through the whole thickness starting from the entrance wound upwardly. The left lung was found shrink and lacerated in the lower and middle lobe with collection of blood and thick blood clots. The exit wound measuring ½ inch length was found at the back, 1 inch lateral to the midline in between 4th and 5th ribs. In my opinion, the cause of death is due to stab to the left lung causing massive blood loss and collapse of lungs and subsequently to other vital organs of the body. Now, my lords, in her cross, there is one vital, important statement, but I'll just take your lordships through the whole. It's short. It is a fact that since the weapon of offense was not produced to me, I have no proof that the injury was caused by the alleged weapon of offense. It is a fact that from my findings, the deceased died due to the injury inflicted upon him. It is a fact that from my findings of the injury, from the injury of the deceased, while inflicting injury to deceased by the accused, they were facing each other. From the injury, it could not be ascertained whether it was caused from left hand or right hand. My lords, this last statement made in her cross, according to the medical officer, both were facing each other. And as per the PW number 2, my lords, the accused seems to be left-handed. Now, my lords, it just occurred to me that if a person is to be stabbed in his left side of the abdomen, if he's a left dominant person, left dominant handed person, it would be going the opposite way, my lords. This is something which, my lords, which had scratched me, because if he was right handed, it would directly go straight to his left side. So that direct force and impact would be there more than the left if he's left handed, because the stabbing was on the left side. I just wanted to point that out, my lords, to show that, my lords, intention is one thing which seems to be amiss in this case.
So
Yes.
if the stabbing took place by left hand,
Yes.
stabbing would have happened on the left
Side.
left
To the
abdomen.
right side, my lords. Opposite, my lords. They're opposites. So if I use my left hand, my lords, the impact would be on the right. Right of the person standing right.
Right.
Yes. So the impact, my lords, the force that would be there.
Injuries on the right side.
Left side.
Left side, sorry.
Unfortunately, my lords, no direct evidence, no eyewitnesses to the stabbing. That is causing the problem, my lords. Lastly, my lords, I'll take your lordships through PW number 9, who is the IO. This will again reveal certain more facts, my lords.
But the evidence here is that they saw the knife on the right hand.
My lords, that is what PW number 2 said.
Two say.
But in cross, she says she does not remember.
She saw the knife on the right hand.
Right hand. Then, my lords, PW number 4 says that I saw it on the left hand. This is the contradictions, the discrepancies, I would say, rather, in the statements, my lords. My lords, I'll proceed with PW number 9, who is the IO, the last of the prosecution witnesses.
Who is it? Okay, 9. There's no 8.
My lords, there seems to be no 8, my lords, yes. Your lordships is right. There is no 8. Seems to have been dropped, my lords.
9 is IO.
9 is IO.
Yes.
My lords, I'll begin. Page 18. I know accused person. I was the officer in charge Khosol PS at the relevant time of incident. On 13 March 2017, ASI Rimoya of the PS submitted suo motu FIR to the effect that while he was on duty at the PS the previous night, that is 12 March 2017, he received telephonic information from Mr. F. Vanal Thanga, Chalrang Village Council Secretary, to the effect on the same day at the evening time, the present accused PC Sanghuna committed the offense of murder by stabbing on the abdomen of Lalroat Moya, son of so-and-so, of the same village inside one residential house at the village. Hence, Khosol police case number so-and-so was registered against the present accused. I took up the investigation into the case. I visited the place of occurrence and examined the complainant. I drew rough sketch map of the crime scene. Inquest examination was done by ASI Rimoya, and he also forwarded the death body to Community Health Center for post-mortem examination. During my course of investigation, I came to know that soon after the incident, the accused dashed off from the crime scene and ran towards Khosol PS to surrender himself. On his way to Khosol PS, he was met by the complainant. He was then barred from his free movement and later brought to Khosol police station. I formally arrested the accused. I interrogated him. He stated to me that in the afternoon time of 12th March 2017, he went to the house of Sanghing Lawa of the same village. My lord, Sanghing Lawa is the father of PW number 2. I'll just point that.
PW2.
Yes, my lords. The place of occurrence, my lords, the owner of the house is Sanghing Lawa. His daughter was PW2, number 2. I'll continue, my lords.
Yes.
There he had some cups of liquor, the accused. By that time, the deceased also came to the said house. They had an altercation, and after a few minutes, the altercation escalated too much. The accused left the place of occurrence and went straight to his house. From his house, he picked up a knife, and with that, he returned to the house of Sanghing Lawa, where the deceased was still sitting there. With that knife, accused stabbed the deceased on his abdomen. Some of the bystanders evacuated the deceased and rushed to Kohai Primary Health Center, but was declared death at the PHC. The accused frankly stated to me that before the date of incident, he and the deceased had already misunderstandings and had a little altercation. On the very day of incidents, He stabbed the deceased on his abdomen with a knife. After committing such gruesome offense, he ran off from the PO, place of occurrence, and took shelter by surrendering himself to the Khosol PS. I collected the DNA report from the confessional statement made by the accused to me, the medical report, and from the statement of witnesses. I found a prima facie case of murder, and I submitted charge sheet against the accused under the said section of law. My investigation revealed that the accused and the deceased, after having minor misunderstandings the previous days, and then on the day of the incident, they had serious altercation. The accused left the place and went straight to his house. From his house, he returned to the place of occurrence with the knife on his hand, and as soon as he reached the place of occurrence, he attacked the deceased with the knife and then stabbed on his abdomen. The injury from the stabbing led to the death of the deceased. As there was a preparation for committing such offense on the part of the accused, the case is really under the offense of murder. So, my lords, as per the IO, the accused went to the house of PW number 2, had some cups of liquor, and due to some altercation between the accused and victim, the accused went to his own house, took a knife, came back to the place of occurrence, stabbed him. Now, my lords, in the confessional statement, I will not take your lordships through the entire record now, my lords. In his confessional statement, in 313, which is at page, my lords, page 4 and 5 of the paper book.
313 is not confessional.
I'm sorry, my lords. Yes, this is the examination of the accused. Your lordships is right. My lords, I'll just...
Page 4.
Page 4 it starts, my lords. My lords, if I may read question 1.
Yes.
The evidence against you is that on 12th March 2017, you went to the house of Sainghing Loa, and from there you purchased about 3 glasses of local made liquor for your own consumption. You stayed there and consumed the liquor. Is it correct? No, it is not correct. The liquor was purchased by my friend Ngai Zwala and not by me, but we together drink the said liquor. Question number 2. The evidence against you is that you stayed the whole day in the residence of Mr. Ramthyang Lima, and at around 4 p.m. you left the said house. You went to the house of Ramthyang Lima to submit electric bill. Ramthyang Lima used to collect electric bills from every house of the village and then submit it to P&E department office at Khosol. He was in turn paid a small remuneration from each of the house of the village. Is it correct? No, it is not correct. The evidence against you is that you came back to the residence of Sainghing Loa. The deceased Rotmoya was there in the said house. You bought a small amount of local made liquor worth about rupees 100 from Sainghing Loa, and then you started drinking the said liquor. After a short while, you had got into a squabble with the deceased over the liquor. Is it correct? Yes, it is correct. So, my lords, both of them were drinking. They had some small altercation. The evidence against you is that you had previous misunderstandings, enmity with the deceased over small matters. Is it correct? Rejected, my lords. No, it is not correct. The evidence against you is that squabble between you and the deceased escalated and both of you had reached your limit. Is it correct? Yes, it is correct. Now, my lord, 6 is the main defense he has taken at the next page, page 5. Page 5, my lords. Question 6. The evidence against you is that you left the deceased at the said place, Sainghing Loa's residence, and went to your house. From there, you came back to the place of occurrence with a knife on your hand. Is it correct? No, it is not correct. I did go home and then went to the house of Ramthyang Lima and submit my electric bill to him. After that, I returned home and took a knife from my house and went to Leipui to check the traps that I had laid for rats, etc. My lords, the accused today is a mystery. That is from the defense witness. From Leipui, I went straight to the house of Sainghing Loa. I met the deceased there. I said to the deceased, Urata, Kanthuka ahoe me isoi felteang, which means, my lords, the accused addressing the victim saying that our squabble was very small. Let us mediate and talk. And with that word only, I was stepping out of the said house, and the deceased all of a sudden assaulted me from behind with a wooden stool. So, my lords, as per him, he was assaulted by the victim. He gave a blow on my right shoulder with that stool. In retaliation, I swung my left hand with a knife on my hand and then hit the deceased. Question number 7. So, my lords, as per him, he says he uses his left. Then again, my lords, it's on the left side. But, your lordships, that I leave to your lordships' wisdom, my lords, as to how to interpret this part, my lords. Question number 7. The evidence against you is that as a result of the knife injury, the deceased succumbed to his injuries on the place of occurrence. Is it correct? No, it is not correct. After I had inflicted knife injury, the deceased was quickly brought to Khozol, CHC, and was declared dead about 1 hour after the incident. I do admit that the deceased got injury from my knife. My lords, I'll stop here and just put out my submissions. My lords, there is no denying that the accused has, my lords, taken the step of stabbing the victim. That is admitted, my lords. But this whole case, my lords, the very element for bringing the charge of murder is the element of intention, my lords. My lords, on that date, on 12th of March, from what is coming out from the statement of the witnesses is that both the accused and victim were intoxicated. And the time within which the incident had occurred, the whole day, my lords, on that date, the accused and 3 others, including the victim, were together at a particular house. They were socializing, watching television as per the PW number 2. Thereafter, my lords, the accused leaves the house, comes back in 10 minutes, and commits the said crime, my lords. Stabs the victim. Now, my lords, your lordships would know, would be well aware, my lords, of the concept of cooling off, my lords. My lords, 10 minutes, accused is also inebriated. For him to have to, for us to say that he may have, my lords, planned and come back with the intent to murder this victim, my lords, that I somehow feel on reading of this, my lords, paper book, that this intention is still missing, my lords. For him to come up within a span of 10 minutes, my lords. But yes, my lords, there is one fact, is that he has come back with a knife in his hand. That fact is there. The knife has been recovered, my lords. That fact is there.
See, question number 2 and 6,
Yes, my lord.
they seem to be contradictory. 2, he says, not correct. 6, now he says,
Yes,
he's gone to Ramthi Anglima's house to submit the electric bill.
yes,
Initially, he denied.
denied. My lords, if we were not to read these statements, and if we look at the circumstances from the statements of the witnesses,
Anything in the evidence about wooden stool?
no, my lords. Precisely, my lords, your lordships have put a very pertinent question. There is nothing, my lords. No recovery of any wooden stool, nor, yes, my lords.
To justify his action,
Yes,
perhaps
yes,
he said that he was attacked by a wooden stool
Yes, yes.
and he swung his left hand with a knife.
No wooden stool, my lords. Not an utterance of that. And my lords, if the wooden stool was used in his medical examination of the accused, there would be some injury, as he said, got hit on the right shoulder. But the examination report of the accused is very unclear, my lords. The LCR is there, but as per the same, it does not show any injury.
What about his condition?
That is also
they,
not reflected.
They were drinking that
Not-
day. There's nothing in the medical report,
Same for the victim. That's the issue.
even for the victim.
Yes. ma'am.
Is it a part of the paper book otherwise?
Yes, yes, yes.
Where is that?
My lords, page this is at page 71 onwards, my lords.
The examination of the appellant.
Prayer for medical examination. My lord, 72 is the accused report, but it is very unclear.
Not legible.
Yes, my lords. Thereafter, my lords, the report of the
72, is it available in the LCR?
it is, my
A
lords.
legible copy?
It's still
Let us
not
see.
as
LCR.
legible.
What is there? Can be somehow read. But what about the other ones? Black one.
Sorry, my lords, I should have marked it.
Postmortem. Station of case. This one, is it? The same thing. Yeah, no. Name of the accused is P.C. Sanghuna. This is the accused.
My lords, the report of the victim is at page 65.
The victim is at 65.
Yes, my lords. Relevant portion is at 66.
Now, thing is, are the formats similar?
No.
The format, one is the PME report format. Page 72 is a format of the casualty.
Yes. My lords, this is all in so far as accused.
He was running a fever, 99.7 or something. He has been prescribed paracetamol.
That's it. My
For
lords.
what?
That is not.
99.7
Seems
what?
temperature. I
Slight
guess.
fever.
Fever. Yes.
Slight fever is there.
The body does get. Slight fever.
Saturation is good, 97%. Pulse, BP also same, slightly on the higher side. But regarding his being in the, not in a normal condition, cannot be.
My lords, unfortunately, no recoveries of alcohol was also made from the place of occurrence. Maybe that would have been something to consider, but.
He came later only. Yes, you may continue.
My lord, 66 is the of the paper book, is the report of the victim. The
Yes.
operational part. But, my lords, again, it is not so different from the
DW number 7, the medical officer's own findings as given in his statement. So, my lords, I'm just pointing out.
Entry was from the front
Entry was from the front.
and it
Outside.
came out outside
Exactly.
between the fourth and the fifth ribs.
Correct. my lords. And, my lords, I must also point out, there are no other external injuries caused. There was no other act by the accused on the body of the victim.
Okay.
Because, my lords, Yes.
The knife pierced through the lungs.
through the lungs.
So the opinion is here.
My lords.
In my opinion, cause of death is due to stab injury to the left lung, causing massive
Blood
blood
loss.
collapse of lungs and subsequent organs of the body.
My lords, I'll take your lordships through the defense witnesses. Their statements are very short, but just to give a background of what defense he was trying to put up, the accused. My lords.
Yes.
With that, I'll end, my lords.
Starting from page
Page
20.
20, my lords. Yes. My lords, page 20. This is, my lords, the brother of the accused. The accused is my brother, and I am familiar with the facts of the case. It is a fact that the accused and victim were work colleagues, as my brother, the accused, was a mistri, and Lalruat Moya is his helper. It is a fact that the accused and victim would also often go out and drink liquor together. As the accused is my brother, I cannot testify to the nature of his character. However, the victim's own uncle on the day of his funeral said in his speech that he had no knowledge of the accused being a person of bad character, and he was taken aback by the events that had unfolded. It is also a fact that the victim's own mother had said that the victim is a person of bad character, and she had often thrown him out of her house because of his misbehavior. It is a fact that from what I could gather from eyewitnesses and people who were first to reach the place of occurrence, and also from leader of community, the accused was extremely intoxicated to the point that he was completely out of his mind and behaving in a manner that was entirely different from his normal behavior. It appears on the night of the incident, the accused was behaving like a mad person and appears to have no understanding of the crime he had committed. In cross, it is a fact that I did not witness the accused and deceased fought each other before the incident. It is a fact that I accepted deceased Ruat Moya was died due to the stabbed piercing by the accused. It is a fact that I am not present and I do not witness at the time when the accused stabbing the deceased. So, my lords, the relationship between the victim and the accused is one of work colleagues. At that point in time, the accused was 53 years old. Accused was 30 years old. My lords, at page 22, this is in the brother-in-law of the accused. My lords, he states, he is the brother-in-law of the accused. He stated that he did not know much about the incident. Long before the incident, the accused and victim got in a fight, and he was present at that time. And he was the one who broke up the fight, but does not remember the time when that happened. At that time, the victim said that to the accused that he would kill him someday. The victim said that to the accused that he would kill him someday. DW number 2 does not know if they bring up the case again or not. Since no one was there during their fight, he could not ascertain how the incident happened. But he remembered clearly that the victim deceased threatened to kill the accused in the previous fight. So, my lords, there seem to be some previous altercations between the parties. He accepted a suggestion that the deceased Ruat Moya succumbed to his injury inflicted by the accused PC Sangluna. It is a fact that he was not there during their fight and did not witness anything. Your lordships then may have DW number 3 at page 25.
This is, my lords, the friend of the accused. He knows the accused person, and the accused in the present case is his friend. Today he stands in the court as a defense witness for the accused person. He was not present at the place of occurrence that night when the incident took place, but as soon as he heard about the incident, he went to the place. But when he reached the place of occurrence, the accused was already detained by the leaders of the community. As per his assumption, the accused and the victim had no enmity between them. The accused PC Sangnuna bears a good character. He often played for the games and sports committee, Chalrang. He is in nature a good-hearted person liked by everyone around him. He was never involved in any crime or never assaulted anyone and had no bad reputation. DW3 believed that the incident happened without premeditation and due to their drunken state. My lords, I'll take your lordships straight to page 27. This is the last defense witness. This is the nephew of the accused, my lords. It is a fact that the said accused was my uncle. It is a fact that I was in Aizol when the said incident happened. But based on telephone conversation to my uncle and aunt who were there at the said village, and when I visited him in jail, I have known the said incident. It is a fact that upon the statement made to me by the accused, both the accused and the victim were friends and were drunk on the said night, which led misunderstanding and result in fighting, and done such action unintentionally and felt very sorry for his action towards his friends as they were very good friends. It is also pertinent to mention here that they did not have any previous issues or misunderstandings between them. It is a fact that the accused was a soft-hearted man and never beat even his children, and was a friendly person. I believe that his action was not his intention, and he did it accidentally as they were quarreled each other on that night. Again, my lords, this is not a direct witness, but a friend of the accused. My lords, the statements, they seem to be again not corroborating each other to have a conclusive finding. But my only point is this, my lords, being the amicus, my lords, that these two persons were inebriated that day. And unfortunately, yes, the evidence on that front is, my lords, not clear, or it's not there. But as per the statements, my lords, even the IO says, as per the statement taken, that they were intoxicated. So, my lords, in a state of inebriation or intoxication, and the interval of 10 minutes from the time of incident till the time of, my lords, when they were together at the place of occurrence. My only point is, my lords, if there would be no chance of having some premeditative state of mind or any intention, my lords. And the circumstantial evidence on which the trial court has, my lords, convicted the accused today is based on circumstantial evidence, which according to me, my lords, and as per what we have examined, my lords, is that the chain of events, there seem to be, my lords, certain lapses here and there. The statements are not totally corroborated. So, my lords, insofar as intention is concerned, this is a point, my lords, which is left unproven. And I say, my lords, I fall under one of the exceptions to section 300. This is as per his appeal, my lords. He says this was a sudden fight. I lost my temper. I was intoxicated. Therefore, my lords, I come under exception 1 of section 300. My lords, I'll take your lordships to 1-2 judgments, my lords. If I may, my lords. Or before that, your lordship. I have some worries.
You say the exception 1,
Yes.
provocation,
Yes,
sudden
my lords.
provocation.
This is as per his appeal, my lords.
No, that's as per his
Yes, yes,
appeal.
yes.
But where in the evidence is that indication that there was sudden provocation?
My lords, unfortunately, I cannot say for one that there is a particular evidence pointing to the fact of this provocation. Because, my lords,
PW number 2, who was the closest in time to the incident, says they were all cordial at her residence, watching television together. Then the victim gets called out after 10 minutes, and then the incident follows. But my only point is, my lords, that again, the state of intoxication, my lords. This is as per the grounds taken.
Apart from the IO
Yes,
and the DWs,
yes.
who amongst the PWs have stated that they were intoxicated?
Stated, my lords. The
State of intoxication, apart from the IO
Yes,
and some of the DWs.
yes, yes,
They mention about them being intoxicated.
yes, yes,
Who amongst the other witnesses
my lords.
of the prosecution
My lords,
have
none.
indicated that they were intoxicated?
None, my lords. PW 9 and my lords.
9 is the IO.
That is the IO, my lords.
IO got the telephone call, he went
Correct.
there thereafter only. And those two persons who were on the road, who came running to help him,
Yes,
did not say anything.
correct.
Number 2, PW2 also did not say anything.
Yes,
It seems they sell liquor in that house.
seems so, my lords.
So,
No evidence led. That is there, my lords. But assuming, my lords, let us say intoxication was another aspect altogether. The time, my lords, because premeditation would require some amount of time, some amount to cool off. Therefore, my lords, since the proximity between the time of the incident of stabbing and the time when the person left the house, that would be too less for, my lords, assuming there was some sudden quarrel. That is also not in the evidence, my lords.
no, cooling off for what?
Cooling off,
Is there any evidence that they had heated arguments?
my lords,
PW2 says that they were in the house, they were watching television, all of them.
Yes, my lords.
3 of them left.
And PW number 9 says, IO says, as per his statement, this is what had happened. Apart from that, again, my lords, there is nothing on record. There is no clear-cut evidence to show that there was some altercation.
What is the citation that you would?
My lords,
Uh,
this is in Prem Chand, my lords. I think this would be the only one I could get, my lords. Prem Chand. Your lordships I have provided. It is very hard, my lords, to even cite because there are some lapses in the evidence, my lords, as per my humble submission, my lords. To clearly say that this case falls in this and is covered by this judgment. But my lords, one thing which has to be kept in mind is that, my lords, the accused is a senior fellow as compared to victim. And his social standing as per the witnesses is that he is of a good nature behavior, my lords. No criminal antecedents. And that, my lords, I seek to put in, and also how certain exceptions are, again, my lords, applicable to his case. Para 29, my lords, if I may read. Para 29 and 30 of the judgment. My lords, if I may read.
yes.
29, para 29. That apart, it cannot be overlooked that while the victim was middle-aged, the appellant was in his late 50s. At the time of the alleged incident, apart from the PW numbers 2 and 3, Shankarrao, Fatade, Umrao, Chad, Ramesh, Khode, so and so were present at the spot as per the version of PW number 2. It is indeed improbable that in the presence of such persons, the appellant wielding a weapon like a knife would come to the spot with an intention to commit the offense of murder, overpowering all of them without any sufficient reason or provocation. In our opinion, the trial court lacked in objectivity by not examining the facts and circumstances as to whether the situation was such as is likely to reasonably cause an apprehension in the mind of the appellant that there was imminent danger to his body of either death or grievous hurt being caused to him if he did not act in private defense. To impute intention to cause death or the intention to cause that particular injury which proved fatal in these circumstances seems to be unreasonable.
So, my lords, in my case also, my lords, I have gone with a rusted knife as per the statement of the prosecution witness, and thereafter committed the crime openly outside the house of at the door of the house of PW number 2. Section para 30, my lords. Exception 4. My lords, this is a mixed case where exception 1 he has taken in his appeal, but it may fall under 4 also. So, my lords, if I may just read para 30. Exception 4 to section 300 IPC ordains that culpable homicide is not murder if it is committed without premeditation, in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the offender having taken undue advantage or acted in a cruel or unusual manner. The explanation thereto clarifies that it is immaterial in such cases which party offers the provocation or commits the first assault. 4 requirements must be satisfied to invoke this exception. It was a sudden fight. There was no premeditation. The act was done in a heat of passion, and the assailant had not taken any undue advantage or acted in a cruel or unusual manner. My lords, I'll just try to fit in the case to these 4 factors, my lords. Unfortunately, my lords, no witnesses can say, because, my lords, the line is that the burden of proof would be on the prosecution to prove that he was guilty under 300 with intention. Unfortunately, sudden fight has not, the factor of sudden fight is not coming clear. But if we go by the statement given to the IO by the accused, there seems to be some altercation for which he had called him out, my lords. So, assuming there was some sudden fight, my lords, the fact of no premeditation, my lords, as I have said, 10 minutes, my lords, from the time of leaving the house and coming back, there seems to be, my lords, I would say that intention would not, to form an intention within such a short span of time, my lords, I would say no premeditation. Act being done in a heat of passion, my lords, if there was a sudden fight and nobody can deny, say to the contrary that there was none, my lords, having no criminal antecedents, and if we go by the statement of the accused, my lords, he has acted in a heat of passion. And lastly, my lords, assailant has not taken any undue advantage or acted in a cruel manner. Only one injury, one stabbing, my lords, no other. If there were several, my lords, stabbing or some other injury marks, that would have clearly shown some sort of, and infer some sort of intention. So, my lords, with that, my lords, I conclude my arguments, my lords.
Yes, my lord. The prosecution has examined 8 witnesses out of 9 witnesses listed out of. From the examination and cross-examination of all the prosecution witnesses, it can be seen that their statements are corroborated, strong, unrebutted, pointing towards the guilt of the accused, that the accused has stabbed the victim. And my lord, from the action of the accused, it can be seen that there is a premeditation and intention to kill. The act of the accused going back to his house, taking out the knife and come back to the accused to stab him, that really shows that there is an intention. And moreover, my lord, there is no evidence stating that there is a quarrel between the accused and the victim. So there is intention to kill, and there is no evidence pointing out the act of the accused is on grave or sudden provocation. So, my lord, the conviction of the trial court is sustainable, and my humble submission is to dismiss this application.
Lords, if I may just, my lord, cite one more judgment, because the judgment of the trial court judgment is based on circumstantial evidence. I just wanted to point the law on circumstantial evidence, my lords. This is Viswajit Karba Masalkar, my lords. This is just to, my lords, assess the court insofar as what is to be considered, my lord. Para 20, my lords, of this judgment.
My lords, para 20. As per this, my lords, it says that the circumstantial evidences should form a complete chain, leaving out any space for inferring the innocence of the accused. I'll read, my lords, para 20 onwards of the judgment.
Ms. Vanessiam, you're done with your submission.
Yes, my lord. What I would like to submit is that as per the 312 examination of the accused, even in that examination, the accused admitted that he had murdered the accused. And there is no explanation as to there is sudden provocation or the quarrel between them. So there is intention to kill. And he admitted that he had murdered the accused.
Where did he admit?
My lord, in question number 7, if I may, the evidence against you is that as a result of the knife injury, the deceased succumbed in his injuries on the place of occurrence. Is it correct? No, it is not correct. After I had inflicted knife injury, the deceased was quickly brought to Kozol CHC and was declared dead after 1 hour after the incident. I do admit it that the deceased got injury from my knife.
In fact, my lords.
Let her complete.
Yes, my lords.
Yes, my lord, here he admitted that he has stabbed the accused. And after 1 hour, the accused succumbed to death. So it is clear that the death of the victim was caused by the accused by stabbing him using the knife, taking him from his home. So he came back to that place of incidents with that knife, my lord. So before there is no evidence about the quarreling or whatever. He just went back home and come back and calling out the victim, and thereafter he just stabbed. So there is no fight between them. There is nothing to show.
What about this question number 6? From Leipui, I went straight to the house of Sanghil Lova. And
Yes,
I
my
said,
lord.
and with that word only, I was stepping out of the said house. He was in the house first, then he came out. Over.
No, my lord, from the evidence of the PW number 2, we can see that the accused called out the victim from
That's
her
why
house.
the accused called out. But here he says that he went to the house of Sanghil Lova and tried to discuss about their differences. And as he was stepping out of the said house, he was already inside the house. He was stepping out of the house. Then he came with a wooden stool to hit him. Then he swung his knife. Left hand, in fact.
Yes, my lord, there is a contradiction with the evidence of PW number 2.
Yes, what else? You said he admitted from
Yes,
this.
my lord.
Is
The action of the accused surrendering himself to the police for his safety. This clearly shows that the accused is in clear state of mind and he is aware of what he have done, what he have committed, my lord.
Is there any confessional statement? No.
No, my lord.
164?
It's not next.
Maybe in the LECR, my lords, not in the paper.
Is it indicated in the judgment that 164 was there?
As per my knowledge, my lords, no.
And if it's not there, then why should we look into the record for 164? If it was there indeed,
Yes.
compilation should have shown that somewhere. The 313 statements have been reflected as abstracted, in fact. Then yes, anything else, Mr. Vanessa?
No, my lord.
Okay. Mr. Jordan, what do
Because
you
I
want
was
to
just
say?
citing one judgment,
Uh,
just on what is to be looked at while convictions are made on circumstantial evidence, my lords. Just para 20 of this judgment, my lords. Because, my lords, this judgment says that facts need to be established. Para 20, my lords.
yes.
The law with regard to conviction on the basis of circumstantial evidence has very well been crystallized in the judgment of this court in the case of Sharad Bhirdi Chand Sharda versus State of Maharashtra, wherein this court held thus. Before discussing the case relied upon by the High Court, we would like to cite a few decisions on the nature, character, and essential proof required in a criminal case, which rests on circumstantial evidence alone. The most fundamental and basic decision of this court is Hanuman versus State AIR so and so. This case has been uniformly followed and applied by this court in a large number of later decisions up to date. For instance, the cases of Tufail alias Simi versus State of Uttar Pradesh and Ram Gopal. It may be useful to extract what Justice Mahajan has laid down in Hanuman case. It is well to remember that in cases where the evidence is of a circumstantial nature, the circumstances from which the conclusion of guilt is to be drawn should in the first instance be fully established. And all the facts so established should be consistent only with the hypothesis of the guilt of the accused. Again, the circumstances should be of a conclusive nature and tendency, and they should be such as to exclude every hypothesis but the one proposed to be proved. In other words, there must be a chain of evidence so far complete as not to leave any reasonable ground for a conclusion consistent with the innocence of the accused, and it must be such as to show that within all human probability the act must have been done by the accused. A close analysis of this decision would show that the following conditions must be fulfilled before a case against an accused can be said to be fully established. The circumstances from which the conclusion of guilt is to be drawn should be fully established. It may be noted here that this court indicated that the circumstances concerned must or should and not may be established. There is not only a grammatical but a legal distinction between may be proved and must be or should be proved, as was held by this court in Shivaji Sahabrao Bobde versus State of Maharashtra, where the observations were made. Certainly, it is a primary principle that the accused must be and not merely may be guilty before a court can convict, and the mental distance between may be and must be is long and divides vague conjectures from sure conclusions. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved. And there must be a chain of evidence so complete so as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. My lords, this burden should have been discharged by the prosecution insofar as invoking, my lords, the charge of murder conviction. My lords, apart from this, I cannot, my lords, as amicus, being there certain lapses in the evidence also, my lords.
Anything you want to ask? To ask. Okay, matter. Okay, we'll consider the submissions made and pass appropriate orders. I heard Mr. Jordan Roming Thanga, learned amicus curiae for the appellant, and Ms. Vanesiami, learned public prosecutor for the state. The learned counsels have made their respective submissions. Hearing concluded, judgment reserved.
Deeply grateful, my lords.
Item number 8.
May I please?
Yes.
My lord, actually, I was just let in just now by the admin. Is this item number 1, Lordship?
Yes.
All right, yes, much obliged. My lord, actually, I was just let in just now. Am I audible, my lord?
You are audible.
Yes, lordship. In the first part, I had technical glitch, so I could not join the lordship.
Okay.
So my lord, this PIL, so and my junior, I think have furnished that 3.6 CR that approval one. So it was on July. It was that 3.6 was approved. CR for constructions of restorations of the road. ATL Isol to Longley Road. This is the documents that we furnished.
Okay. So
So, Your Lordship, so it is not a part of the record at the time of filing of their counter affidavit also.
why was this PIL filed in the first place?
In the first place, because that the road between Lunglei to Aizol was very bad during those period, even now also.
PIL was filed in 2022.
Yes, even many NGO, MZP, YMA, they had issued press release also.
Okay, but this PIL was filed in the year 2022. Today you are showing us an order of expenditure sanction of 3.6 CR,
Yes,
which was issued on 22nd of July 2024.
yes.
So what do you want to say?
My lord, that my submission is that if that is the sanction, so they can utilize that 3.6 as per the directions of the court within a specific period of time.
No, is there any indication that they are not going to utilize this money?
My lord, actually, even before also there is such kind of sanction also there. There is a huge amount sanction, and respondent number 5 was the contractors, and he did not maintain the road properly. He did not construct the road properly. It is admitted position by the state respondent also in their counter affidavit. They had issued numbers of times.
No, that is why there was a direction from this court for his appearance. He has not appeared so far. And now the performance guarantee of the contractor is going to be utilized to
Yes,
complete to repair the road.
yes,
So in the last location, they had submitted that the estimated amount of 65,91,000 has been approved.
yes, Your Lordship.
Now, in addition to what has been estimated and approved from the performance guarantee, today you are producing this sanction, administrative approval for expenditure sanction of 3.6 CR.
Yes,
So this is in addition to this 65.91 lakhs.
it seems so.
What is your instruction, Miss Mary?
My lord, I have not been served a copy of that, and I do not have any information on the approval of the 3.6 CR.
Fine.
But
You take a copy, you get back to the court on Wednesday. Because this sanction is done in the month of July.
Yes,
So whether the work has started or not, let us know.
Lordship.
You tell us. Please write down, Mr. J.C. London Sang, a learned counsel for the petitioner, has produced order dated 22/7/2024, issued by the Under Secretary to the Government of Mizoram Public Works Department, by which the Governor of Mizoram has accorded administrative approval with expenditure sanction of 3.6 crores during 2024-25 for restoration of Aizol-Thenzol-Lunglei Road, open bracket 100.00-143.00 KMP. So this is only for a stretch of 45 kilometers.
Yes, from the figure, it looks
From?
10 to 143, 100 to 143 kilometers.
That is which area? It's from Tenzal to Lungle.
From Tenzal to Lunglei, I think so.
That is the patch which is very bad.
Yes, very bad.
Miss Mary L. Kiante, learned government advocate, shall obtain instructions as to whether the work is being implemented by the government in terms of the administrative approval and expenditure sanction given by the next court date. List again on Wednesday,
Lordship,
30th of October 2024. You make Xerox copy and give it to Mary. What is the other letter?
those are approval. After that,
Okay.
the financial approval.
All these papers should be photostated and given to Miss Mary. Okay.
Much obliged.